So, my lord, Union Government of India is following blacks, but it is following an antiquated edition. If you are following the same definition or the same dictionary, I say follow the latest version. You can't follow a version, which is 50 years old. So, ultimately, it is this. I request. For example, the two petitioners in the first case, who are they? Two individuals who met with a bond of faith, love, partnership. They want to, reach the status of a married couple, like the other person, and have a family. They cherish the same, what is cherished by the others. They want to lead a dignified life, what the others also live, and not always to be looked upon. Look at them. For that, your lordships have removed the one block, that they can't go to jail. The second step has to be affirmative, which is a recognition of the right to marriage, so that we are equal, recognized by the state, so that, society then follows the state. Because society, is resistant to change. Human beings are resistant to change. So society follows what the law is, and the law is what is, said in Parliament or what is declared by this court. That is the law.
The only thing which we'll also need to apply mind to is, like, take your chart.
My lord.
You see the US, September 96, the federal government enacts the Defense of Marriage Act.
Yes.
Which says that the federal law shall not recognize same-sex marriage. Then comes 2013, of course, the UK.
Oh, the UK.
That's right.
Yes.
And then 2013 comes the act in the UK, conferring upon all same-sex.
Windsor is also there.
Yes.
Windsor, 2013.
Yes, that's right. Windsor.
When DOMA was struck down, the federal law was struck down.
And struck down DOMA.
By law.
Right. Then comes in the UK, you have a legislation which recognizes same-sex relationship.
My lord.
And then finally in 2022, you have the US Respect for Marriage Act.
Yes.
2022.
Yes.
So you had in the US something which was debilitating, which was removed from the statute book. Then you have something positive which is enacted in the UK, and then which is enacted in the US as well, the 2022 legislation. Now, what we therefore have to really consider is exactly what the other side is
Yes, I understand that the drift of the question.
These essentially matters where even in the US and the UK, legislature has intervened earlier by outlawing and later on by recognizing. In the absence of legislation, how does the court go about it?
Yes, I understand the question.
Is there a contra? I mean, is there any indication in our legislation precluding the court? Or is there a legislative space within which the court can then...
I understood the question. By respectful submission, one minute your lordship may see the judgment is over Jeffel in 2003.
What is the right of marriage and what is the constitutionality of the enforcement of right of marriage? Because what they are saying is, you live together, you want to do whatever you want. But you can't tell that you want to perform whatever ceremony you want to do or whatever you call it as a marriage. But you can't give an imprimatur and say that that will be registered or recognized. And so therefore, we'll have to go back to what is the enforceability of a right of marriage.
So, my lord, if I may answer for the Chief Justice. My lord, if your lordship sees 2015, I have understood the drift, my lord, there the legislatures acted. They acted. Pursuant to the judgments or the feelings of people, they acted. Here, but in 2015, my lord, as far as Over Jeffel is concerned, it recognized the right of the same-sex marriage and legalized the same. That was a judicial imprimatur. It legalized.
Correct me if I'm wrong.
Sorry.
There were constitutions and there were laws which were amended or enacted which prohibited gay or same-sex marriages. Because of the actually struck down that. Said
right.
You have a right to marry. Now the wheel has turned a full circle where you have a complete federal cover in the sense that you have a
Yes, your lordship is right.
Right? So we are at that stage.
Yes. Yes, yes, Lord. So, my Lord,
One is the declaration part
which I am seeking. My Lord, what I am respectfully submitting, answer to both of your Lords, three of your Lords. My Lord, if, as distinct from UK and other places, if we have a fundamental right under 14, 19, 21, whatever, to be treated as identical and equal to our other brethren, then the full enjoyment of our rights to be equal to them includes the right of dignified life. If it includes the right of dignified life, which includes the right to choose a partner for marriage or choose a friend or a freedom of expression, whatever we want to express, we don't do in writing. Expression can be not in love or other forms. And that it is now settled that it is innate. It is not an acquired thing. Call it what you like. If the rights have to be identical, then I must get the recognition of my union the same way as the recognition of the union of two others. And since it is based on an infraction or an implementation of my fundamental right, I can come to the court and the court need not wait for the legislature. And there is a direct passage, my Lord, in one of these judgments, which I have. So, my Lord, I can't keep waiting. There can't be a mandamus to the legislature. Legislature may or may not do. I cannot force the legislature, neither can the court. By that time, our lives will have gone. And our fundamental rights, my Lord, will be made. That there is 5 judgments of the Supreme Court saying that you have the same rights, same panoply of rights, passage after passage. If it is the same panoply of rights, there must be a remedy. And the remedy can only be a declaration to that effect by the highest court of the land, saying that this is a fundamental right. And once it is the imprimatur of this court, then, my Lord, it must follow that the state is bound to respect it, then the society will respect it, and the stigma in the workplace or the public place will then go away, and I'll be able to enjoy, my Lord, a unit of marriage, a unit of family. Because that is what is accepted in our society. So in short, I need not wait for Parliament to do what it wants to do, because there can be no mandamus. And then the Lordships have said repeatedly, if fundamental right is involved, the doors of this court are open to an individual. I have a right to come here. I have a right to complain that this is what is happening to me in real life. Lord, it's happening to us in real life. When we go out, when we talk, when we meet people, slowly, my Lord, it is being accepted because the criminality is gone. But not to its full panoply. People say, what right have you to get married? Which law? Which court? You got a judgment from the Supreme Court in the first one, there is the second one. So unless and until, you know, I get a recognition of law under Article 141, because that the other legislative thing is not available. Vishakha or whatever. If I have, my Lord, a right, that right must be examined by the court, and if found, it must be guaranteed. 32 itself is a part of fundamental rights. It must be guaranteed by the court. How will the court guarantee it? My Lord, it's not a case of property that my Lord should take it from him and give it to me. Or some money, my Lord, take it from me and give it to him. Your Lordships will, my Lord, give it by a process which is known to law, which is, my Lord, interpretation of my fundamental rights, and thereafter interpretation of the law concerned. And then leave it to Parliament that this the court has done. If you want to formalize it in law, such is what put it. If you want to formalize it in law, you jolly well amend the act or do bring a new act, as these countries have done. But if you don't, the law can't remain static. Law moves, society moves, there's evolution. Rights are different, things are different, thoughts are different. Therefore, the court will act when it is called upon to act. It will do whatever it can within its judicial parameters.
So in other words, like two alternate lines of approach for the court. Assuming you are right that you are entitled to a declaration.
Yes.
I mean, assuming, of course, we have to hear the other side. Assuming you are right that there should be a declaration of the right to marry, then there are two courses of action according to you. Either the court then finds a legislative void in that Parliament has not legislated explicitly to recognize the right of marriage, and therefore finding a legislative void, you supplant that deficiency so long as Parliament enacts law. The other option is to locate locate the modalities for implementing that declaration
Yes.
in existing law.
Correct. So, my lord, my short, respectful, most respectful answer would be, if you take Vishakha as an example, in Vishakha, there was no law at all. The court laid down a set of rules which was to work as interim law, if I may use that phrase, interim law or rules and regulations under Article 141 till without Parliament Act. Parliament then acted. But the void was filled up in Vishakha in this form. I am saying that in our case, because of our past history, Vishakha had no history. There were no cases before that. We have past history of Puttu Swami, Navtej, all these cases, Shafir, etc., etc. In that past history, all I am requesting is the second step. And the second step to no, my lord, I am not saying that your because, my lord, life is passing by us by. We can't wait. How long will we wait? I- sorry.
I know. I can't get this conversation. Can't get it. What happened?
If I have a constitutional or a fundamental right, and your lordship declares so, and this act remains the same, then there is a conflict between this and the constitutional or a fundamental right so declared. So one way is that this must give way to the constitutional declaration. We don't want it to give way. The simpler way is to read it down, to be in accord with the declaration, Lord, which I am seeking. Yes, because, my lord, legislative drafting of 1954 to, my lord, my constitutional right after 50 or 70 years. This drafting cannot stultify what I am constitutionally entitled to get. If I am right, if I am right, if I am wrong, it's all over. If I am right to get a declaration of the nature that I am seeking, my lord, in 2023, then there is no way that, my lord, a drafting of a statute in 1954 will, my lord, give, will
thoughts. In
website is not being shown. This is the website.
our model, where your lordship in constitutional adjudication have equalized and brought the left out category into the existing category, my lord. Not just the executive instruction case in Nakara. In All India Sikkim old settlers recently, following Vishnudas, Handimal, ITO Lawrence and other cases, where, my lord, some people were left out of certain benefits. Your lordship said striking down will deny everybody the benefit. I will now equalize them, my lord. A good body of case law. The other is the Fowry model, my lord, of South Africa, where they said the common it can never be that, my lord, you await for them to legislate. That should be, my lord, submitting to, my lord, popular will, which, my lord, is completely contrary, anathema to fundamental rights. The whole idea of fundamental rights is to, my lord, to keep it out of the reign of majority.
Now that we've understood, broadly we've understood the canvas of the matter, then we can really, at least at this stage, we're not ruling it out for the future, we can steer clear of personal law in that case. So if we steer clear of personal law, then perhaps we make the first, that is one possible option as you opened it up.
As far as two of us are concerned, we are not dealing, there may be other people.
My lord, there are concerns about the Hindu marriage.
Because it may not be necessary for the board then to get into more text issues pertaining to personal law.
It's 45.
Yes, my lord, Hindu marriage
It's 45.
So perhaps you can all address us on this aspect. That's why when we began, we
Can I take 5 minutes?
Just a minute. The possibility the states must be heard. It's a constitutional issue.
Dr. Goswami?
My lord, thank you. My Lord, the Chief Justice may recognize, my lords, that the Hindu Marriage Act is not an issue necessarily of personal law, it is statutory law. And we will demonstrate that. The terms of the Constitution, the reform of the Hindu Marriage Act has always been in the context of statutory law. So, my lords, to that extent and that extent only, in the context of statutory law and making statutory law workable, because my lords will know, my lords, that the origin of the Hindu Marriage Act, the Hindu Code, did something that was not permitted in sacramental Hindu law, which is intercaste marriage, Sagotra marriage, divorce,
Inheritance to Dr.
inheritance.
Swami, but there's also Dr. Puruswamy, there may be some amount of sage wisdom in also going about our interpretative task in incremental manners, because otherwise, do we then confine ourselves only to the Hindu Marriage Act? And what about the Parsi Marriage Act? What about the Muslim law? What about the Jews? What about the Buddhists? A lot of other communities. Therefore, perhaps one option for the court, because the Constitution itself and the law is itself evolving. So, and the court has to be mindful of the fact that we are doing, by process of interpretation, what you are calling upon us to do. So it may be some element of judicial discretion, and perhaps going incrementally, covering a canvas for the present, which would substantially then, assuming that even there you are right, because you have to hear the other side, confine yourself to this incremental canvas, and then allow society to evolve, allow Parliament's perceptions to evolve over a period of time, because Parliament is also responding to the evolution of society over a period of time.
As the canvas after Ms. Puruswamy is finished, I want just 3 or 4 minutes. You finish? But it's only 3 or 4 because Lenfred is given, my Lenfred is given.
Because we can't deny the fact.
On canvas,
We can't deny the fact that there is undoubtedly the legislative element also involved, which is why there are states, the Parliament, the bodies.
my respectful submission.
Having regard to that, we need to balance out various facets. So this might be perhaps one way forward.
That's the only thing I'll say to this.
So we don't have to decide everything to decide something in this case.
No, my lords, I follow. The only thing
There are,
say,
Swami,
yes, my lords.
one is the channel pointed out by Mr. Rossi in a restrictive sense that only construe the Special Marriage Act. If it founds favor with us, it will give us status of marriage. If it not, he rightly said you are out. Therefore, whether other issues at all arise or don't arise, will depend on how we interpret this aspect. Other issues may survive for another day, or may not survive for the time being for another day, depending on what view we take on this core issue. And in the wisdom, as the Chief Justice said, sometimes incremental changes in issues of social and society ramifications are possibly a better course. There is a time for everything, there is time for some things to come. Therefore, what was being suggested was, can we, for the time being, confine it only to this limited issue? Don't step into, let me complete. Don't step into personal law issues under different religious norms. Don't get into any of those issues. But only say that, can the Special Marriage Act be interpreted in a manner by reading into it a gender-neutral situation? Period.
Can I say, and perhaps you can then help us, you can assist us, and we'll ask the solicitor also to assist us on how we can sort of develop the notion of a civil union, which really finds recognition in our statute, namely the Special Marriage Act. See, because now, for instance, I'm sure you wouldn't also deny the fact that between the time that Navtej was delivered and today, our society has found much greater acceptance, say, of same-sex relationships. For the last 5 years that we have seen it unfold,
Definitely.
and that's very positive, because we find that there is a greater acceptance in our universities. And by the way, our universities don't consist of only urban kids. They all come
Yes.
from the
So, of course,
smaller,
over the country.
smaller areas, yes.
Yes.
But there is this acceptance which is evolving. So, in this evolving consensus, the court is also playing a dialogical role to
Yes.
create that consensus and move towards a more equal future.
My lord,
While being conscious of our own
Yes.
limitations, which
Yes,
we can't
Lord.
deny in the legislative arena.
I follow that.
I-
My lords, the only request I would make is that the question may be left open to be adjudicated.
Obviously, we're not going to reject what we don't.
Yes, but.
We can always confine our
Yes.
canvas and then not reject.
Yes.
Obviously not.
Yes. And my-
That is not necessary for the court to do at all.
It's simply this, that the second point is simply this, that marriage is not only, as if that were not.
But leave broader and broader issues for an evolving future.
But marriage is not only a question of dignity, as if that were not enough. It is also a bouquet of rights that LGBTQ people are being denied post-job. Right? Those rights are simple things. Bank account, life insurance, medical insurance. I, for instance, frankly,
Rental accommodation.
I cannot buy SCBA medical insurance.
Citizenship.
I am a member of the SCBA bar. I cannot buy my family medical insurance from the SCBA. So this is of how rights are exercised. Rights are exercised when you are able to protect your relationships. One facet of that right is a constitutional value of dignity, equality, fraternity. The other facet of that right is the day-to-day business of life. And the day-to-day business of life is all of these things. Now, when we look at law in India, and all common law is premised like this, that most rights flow from this notion of blood relationship, i.e. either being born into the family or being married. That is the problem, my lords. And so, therefore, short of full marriage, whether my lords find that under the Special Marriage Act or be that as it may, short of full marriage, it will mean, if it's short of that, it will mean that subsequently, not just Mr. Rudgi, Mr. Kripal, we will keep coming back to court to have to litigate individual issues of discrimination. I am not able to nominate my partner for life insurance. But these are not theoretical issues. This is our life. Right? So therefore we say marriage, because that is the
But on the canvas, Maharaj, I want to say this first.
Yeah.
On the canvas, just 1 second. But on canvas, there are two words here. Of course, on the confinement, Maharaj, it is with great respect, the better profitable way of doing it. There are very valuable arguments by the Hindu Marriage Act batch or even Maharaj by other personal laws. Both of us, Maharaj, in the two lead matters are not arguing that. We are only in SMA. So, Balas, a way to start would be to Balas limit it there. I entirely bow down to what is calling for marriage. But Balas, on the canvas, just 3 or 4 minutes, there are 2 crucial words here: marriage and persons. Same sex is a slight misnomer. The correct word is person, not same sex. I'll just take 3 or 4 minutes first. Marriage largely, my learned friend is covered. But there are 2 categories of consequences. These are consequential issues she is raising. One is the minor or major secular consequences of marriage. Your lordship is not in this matter. In the event that your lordship holds marriage to be this way or that way, not creating an empty shell called the word marriage. It has to have some consequential benefits. Marriage, in any case, now you can have a living. You need not even call it marriage. It is because of the consequential benefits. So your lordships may need, this is entirely a lordship discretion. I understand it's a great advance in law if your lordship even were to interpret same person marriage as a marriage. I'm not at all diluting or reducing that. But your lordships, according to me, even in this more limited canvas, must consider traveling a little ahead. One category is what my learned friend has said. These are secular incidents of daily life. They involve nothing beyond that. And your lordships can have a reasonable listing. Now there are larger issues which your lordship will explicitly keep open. I would say that even those can be covered by marriage, but possibly we are too early to start doing that. There is succession law, certain aspects. There is adoption law, certain aspects. There is certain other things. We are not at all giving it up or lessening it. But your lordships in this, the crucial word which is incremental. I always believe that your lordships in such matters like a rubber band. Your lordship expands incrementally slightly. You stretch the rubber band too much, your lordship is pushing pressure that the rubber band will break. Because that slowly movements is on the societal view of the rubber band. Now adoption, according to me, is crucial. There may be some non-adoption issues which your lordship may not consider crucial. I'm not able to in fact itemize, but your lordship will guard against holding on the left hand, in the event your lordship so holds, that marriage of same persons is valid, and on the right hand, make it an empty shell. That is point 1. Point 2 of the canvas is even more important. The point arises from not having to come to your lordships every day. That's why I said the word is actually more appropriate. I've looked into this some literature, same person. Now, your lordship has got, one is heterosexual marriage. Lordship will call it this side. One is man-man or woman-woman, which we call homosexual or lesbian on the other side. Now, there are 2 actually parameters of differentiation. One is sex-based, which must include between the man and woman sex. There is also a whole range of combination of persons with special biological features. It's not only man, it's not only woman. The second category is gender. That is the masculine, feminine. So a male body can be imbued and overshadowed by completely female psychological instincts, and vice versa. So therefore, once your lordship holds today, assume, as a matter of argument, that your lordship were to hold that same-sex marriage is valid. Same-sex in the sense of man-man, woman-woman. It is not intended that persons who are in this, what is known as the whole range of shades, the complete spectrum. What your lordship we tend to say LGBTQ. I looked it up, it is L, lesbian, G, gay, B, bisexual, T, transgender, Q, queer, I, intersex. And then your lordship says A, asexual. And then your lordship says plus plus. The actual correct thing is, so this plus plus is a whole shade, a spectrum of different hues and colors. Now clearly if your lordship were to hold same person marriage, your lordship doesn't mean to limit it to same sex marriage. In the event your lordship were to hold, so that your lord doesn't have a tomorrow a new person coming here and saying this. So the correct formulation would be two consenting adults. I'm only giving a summary. 2 consenting adults along the bodily, gender and sex spectrum. Either you define by gender or by sex spectrum. This is the other facet. Now all of this can be profitably started with SMA, because your lordship is making a start. Were your lordship to leave the rest of it explicitly open, or your lordship may have a deferment and have it considered separately, it's entire your lordship discretion. They have also valuable points, are not only in the Hindu Marriage Act category, other people also. Hindu Marriage Act category is there also. Secondly, Manoj, let us be very clear. I heard with some alarm my learned friend's opening intervention. Nobody is arguing at the moment, nobody, I will not say, at least the two of us, or the three of us, are not arguing personal laws at all. We are not. Number three, we are, what is the meaning of this repeated thing about state intervention? Your lordship, for the first batch, is interpreting this way or that way, whether SMA, and our arguments, that is my arguments, are in two parts. One is these fourfold parameters of discrimination, which is the most important, 15, 14. Second is freedom of expression. The very interesting facet of freedom of expression, the lordship has said, is symbolic in a community sense, not only individual. Third is dignity, 21 and other things. Fourth is how to remedy it. And the second part of the submissions is the entire notice objections regime of the SMA. That part would have to be held unconstitutional. The first part is interpreted. If your lordship is with us on that, the second part would have to be interpreted, unconstitutional.
The notice issue is even in a heterosexual marriage, because you are saying that even
Yes.
in a heterosexual marriage, the fact that you have to give a notice and have people object to whether there should be a marriage or not is unconstitutional.
The funny part is, and this is just an aside, that the object, howsoever noble, of having this section 5 to 10 regime is being proved by statistics on the ground to have the exact opposite effect. Exact opposite. Your lordship invites opprobrium, oppression, physicality, violence, elimination, extermination. And I am asking myself one question. Your lordship has conditions of marriage in all, even Parsis, Christians, Hindu Marriage Act, other acts. Conditions of marriage are there, but something or the other is there. If you give an affidavit saying I am satisfying the conditions, and your lordship subsequently finds the affidavit to be false, or any spouse finds it to be a third party find, it can be struck down. It's void or voidable, it's struck down all the time. You don't need to have a notice period in advance after the conditions. This is peculiar to only the SMA. Your lordship is not allowing those conditions to be violated by the non-following of objections. It's a absurd situation. Now that being the situation. Yes. Sorry, I can't. This intervention about state objections.
No, I am saying therefore, you say you don't want to touch personal laws, correct? And we also put you don't touch personal law.
I am not.
Then the argument is in a very limited compass or
Focused.
Then confined is, can we in the Special Marriage Act read a person instead of the definition of a woman or man?
That's all.
And leave everything else for some good time in the future.
My lord, just one aspect.
And no state intervention inhibits your lordship.
My lord, just one aspect.
I think we'll now get back to Mr. Rodgi. So we'll get back to Mr. Rodgi.
My lord,
now
my lord.
clarify. 1 second, just 1 second. 1 second. We have, I think, all of us on the bench have now clarified the area, you may call it the limited area or the area that we are going to explore in this case. Let's hear Mr. Rodgi on that, because I think
on the ambit, my lords, briefly, on the ambit, if I may be permitted.
Yes.
My lords, we have challenged in addition the other two secular legislations, and many of us have, which are the Foreign Marriage Act and the Citizenship Act.
My lord,
My lords, with regard to the Citizenship Act, the word spouse has been used in 2015, subsequent to all of these other legislations. So if the doctrine of casus omniscience is applied, all that is required is very, very low-hanging fruit, my lords. All that is required is to be said that spouse means spouse.
See, one thing is, either we confine it to this, the debate will be limited and we'll know whether we agree with you or not today.
Well,
If we don't agree with you, nothing survives.
So,
All those issues, all other issues don't survive.
But sir, when you are,
If we, one,
my lord,
if we, suppose we agree with you on
Yes,
this
sir.
issue, then in what ramification, what nuance the other thing survives will be a second innings.
my lord,
Second, third, what time?
Look, the Foreign Marriage Act is actually a secular act which is really a takeoff from the Special Marriage Act. So that would have to be included in this canvas.
Can add supplement.
It is secular. It is only.
Let's do this. Let's do this now. We'll now start with Mr. Rodgi's submission, so that we can now look at it. We can now look at it with a sense of a constitution bench hearing.
So that it's there. My Lord can tell us whether we should then address. My Lord, as Dr. Singh has already addressed, the petitioners before you are not necessarily same-sex couples. In fact, in my petition, the Ritu Purna Bora petition, there are petitioners who have anonymized themselves because they are coming from oppressed castes and communities. They are trans persons, irrespective of sexual orientation or gender identity. The relationships are contentious, so perhaps same-sex will not include them in that question. I will.
Yeah, therefore the emphasis is on personhood.
Person, same
On
person.
person.
Same person.
Aspect, we are also some family.
Consent.
Typical family. Can there be, like there is a living, can there be a chosen family, particularly when my natal family is hostile? These petitioners have faced hostility and violence from the natal family.
That's the perspective you need to take.
A chosen family ought to take care of them and their accruing rights.
All right. Now, Mr. Rodgi, you can open now.
can I,
Mr. Rodgi, now tell us about what's the time estimate for you?
Milord, all my time has been hijacked by people on my side.
No, but now we sort of, now the constitution bench begins as a conference. Now confine yourself to this.
Only this.
Lord, your lordship,
Just only this.
Lord, your lordships, while fixing the remit of the matter also, your lordship said that we would hear the segment. Would your lordships like to consider hearing us? Your lordships have fixed the remits.
All right. Yes, certainly, Mr. Yes, Mr. Tumata. Certainly. Yes, sir.
Lord, and this is, my Lord, I must, my Lord, make it. My Lord, I in fact achieved an impossible thing today, my Lord, making my Lord the Chief Justice angry. Few people have done in past, but I am not in very excellent company, my Lord. I must confess that. Lord, first of all, the question really, my Lord, we are misdirecting the question. The question is not the right of equality, right of dignity, or right of privacy of persons who belong to LGBTQ community. That is first. The question is right of conferment of a socio-legal status and whether that can be done by judicial adjudication. But so far as, kindly give me 15 minutes to give the chronological events. But there was no law governing, my lord, the rights and other rights and other, my lord, immunities to the LGBTQ community. Nalsar judgment came, thereafter Navtej Johar came. Lord, now kindly see, my lord, my affidavit. I am not on the merits of the matter, my lord. On merits, I have different arguments. Please see the Transgender Act. Most of the arguments, my lord, are covered. There is no legal lacuna. There is a statutory framework and there is a conscious omission by the statute. My lord, in my IA, my lord, I have annexed the small act. My lord, this is 2019 Act after Navtej Johar.
I'm not talking about transgenders.
Lord,
My lordship have not on transgenders. My case is not on transgender.
Lord, my learned friend may allow me now. My lord, I never interrupted him.
But then, sir, I am on my levy. I want to finish my thing.
Lord, he has not seen the act. Otherwise, he would not have said this.
Wait. You have permitted your side to
Yeah, I know that.
Just open and give
get a
us a...
perspective.
No, I am not saying no.
You shouldn't plead violation of
I'm
article.
not complaining. I want to get on with
You
it.
also get a right to set forth the contour, then we may be able to put some.
I appreciate, no, I'm not.
How we are limiting what we propose to limit. So that then, unless you know what he has to say, how.
Lordship, this is of course not subject to my first respectful submission about the maintainability, but my lord, just I'm assisting your lordships on this. Lord, this comes after your lordship's judgment of 2017, after a Johar judgment. Lord, please see, my lord, so that my learned friend rest assured, page 34. Your lordships have that, my lord, my application.
The act actually.
You've got the act, your lordships have the act, my lord. Kindly see section 2. I'll not read all sections, but some of the sections. Appropriate government, your lordship can skip. Establishment. Define family. Define inclusive education. Define institution. Define. Please come to 2K. Transgender person means a person whose gender does not match with the gender assigned to that person at birth and includes trans man or trans woman, within bracket, whether or not such person has undergone sex reassignment surgery or hormone therapy or laser therapy and such other therapy, bracket over, persons with intersex variations, gender queer and person having such socio-cultural identities as so-and-so, so-and-so, so-and-so. Correct, my lord? Your lordship's concern, freedom of choosing sexual orientation, no objection, my lord, cannot have any objection. That's my lord's judgment. Freedom of privacy, no objection, act take care. Discrimination, there cannot be, the act takes care. I will not show to your lordship. The limited question is conferment of a socio-legal status and whether that can be done by judicial adjudication, and I'll come to special marriage act. Lord, now please see prohibition against discrimination. Lord, all arguments that we are not getting this, we are not getting treatment, we are not getting, Lord, please see this. No person or establishment shall discriminate against transgender person on any of the following grounds, namely the denial or discontinuation of unfair treatment in educational establishments and services thereof. And transgender here means LGBTQ plus, not transgender as we colloquially or conventionally understand. The unfair treatment in or in relation to employment or occupation, the denial of or termination from employment or occupation, the denial or discontinuation of unfair treatment in healthcare services, the denial or discontinuation of or unfair treatment with regard to access to or provisions of enjoyment or use of any goods, accommodation, service, facility, benefit, privilege or appropriate or opportunity dedicated to the use of general public or customary available to the public, denial or discontinuation of unfair treatment with regard to right of movement, denial or so-and-so unfair treatment with regard to right to reside, purchase, rent or otherwise occupy any property. These are all criminal offences if there is a denial. Denial of access to removal from unfair treatment in government or private establishment in whose care or custody a transgender person is, then recognition of identity of transgender persons. Recognition of a transgender person shall have a right to be recognized as such in accordance with the provisions of this act. Right to dignity, right to personhood, as my Lord, the Chief Justice said. A person recognized as transgender under subsection 1 shall have a right to self-perceived gender identity. Application for certificate of identity, but not statutory certification is given that you are falling within the definition of transgender under 2K, based upon which you exercise your rights. And if there is any violation, there are penal provisions. Then issue of certificate, change in gender, even if in LGBTQ, there are changes which take place because of hormonal therapy, other therapies, operation, etc. There is a concept of fluid gender. Sometimes a person is male, for a few days he is a female, etc. etc. Let's not go into it. That's on the marriage, and we have much to say on that. Change in gender. After the issue of certificate under subsection 1 of section 6, if a transgender person undergoes surgery to change gender, either as a male or female, such person may make an application, then he gets a new certificate. Obligation of the appropriate government.
There are statutory obligations, either central government or the state government, as the case may be, to take steps to secure full and effective participation of transgender persons and their inclusion in the society. The appropriate government shall take such welfare measures as may be prescribed to protect the rights and interests of transgender persons and facilitate their access to welfare schemes framed by that government. Appropriate government shall formulate welfare schemes and programs which are transgender sensitive, non-stigmatizing and non-discriminatory. Appropriate government shall take steps for the rescue, protection and rehabilitation of transgender persons, etc., etc. Then, my lord, obligations of establishments and other persons. Lord, there is a provision for a reservation for transgender persons. It's not, my lord, right now nobody is arguing the question of dignity, respect, privacy, etc. Right to choose one's sexual orientation. The definition is widely worded. Any deviation from the normal sexual orientation is protected under 2K. And, my lord, rights are given and any discrimination is criminally prosecutable. Right now, the limited question is, can by a judicial adjudication process, this honorable court create a institution of marriage for the simple reason, Lord, whether we like it or not, whether they give it up or not, whether, my lord, your court would go into it or not, it necessarily affects personal laws. Lord, Hindu Marriage Act is a codified personal law. Islam has their own personal law. Part of it is not codified. Hindu law also, part of it is not.
Into it, so sir, we said
Only a minute.
to them that so far as personal laws are concerned, we are not getting into that arena at all.
That's not the point. Somebody who is Hindu, who is not here, can come and say that, why did you not give me the same treatment? I want to be Hindu, I want to marry under the Hindu Marriage Act, and if you give benefit, we are not getting into it. Why?
Getting into it, so then where is
The Lordship will have to. Right now, your Lordship don't have that argument.
There is no compulsion, we must get it.
Only a minute. Like, can I?
You don't have to decide the broader in order to decide the much more restricted arena.
Another aspect, and which I. That confining the remits, my lord, I have something to say, my lord. Lord, your lordships would have Hindus, Muslims, everyone, whether your lordships go into or not, everyone will be affected, and therefore the central government very respectfully but specifically, my lord, prays that states will have to be heard.
Yes, sir. We are trying to pose to this, sir. If we are not touching the person, it's like saying that you must touch personal law. We don't want to touch personal law. We don't want to touch personal law, then why state should be heard? We are confining our event at the moment only to one issue. So for that issue, whatever has to be heard, for that issue.
Marriage?
Under the special, completed, give me answers. Under the Special Marriage Act, can we read it in a manner that it is a person? That's all. We are saying we are not going into it. So why should there be a compulsion on the court, you must go into it?
Mr. Solicitor,
That's
can you
it.
give an example of what you're trying to add? Because if the remit is being defined in this manner, how do you say that this has some other?
Yes. Lord,
That's-
one Mr. A is Hindu. He wants to continue as a Hindu. He wants to get married under the Hindu Marriage Act. He wants to undergo the.
We are not rejecting or accepting. We are saying we are not doing it at the
But
moment.
we are then begging the question, my lord,
Maybe.
to reach somewhere. We are, my lord, short-circuiting the issue, my lord. That's kindly, my lord, allow me. Kindly let me come. My lord, I am for the first time begging that I may be heard.
Heard, what do we do?
I am obliged.
Understand what is that you are saying? We are saying we have confined them. They may have opened a very wide chapter. We said no, we don't want to get into that wide area. We don't get. say we are only deciding this A issue, we are not touching other issue. Nobody is being prejudiced because we are neither rejecting it nor accepting it. Then we can't be compelled to hear everything else.
No, nobody is compelling, my lord. At least on our side, we are saying your lordship should not hear. We are not compelling.
But you are saying don't hear this alone, hear everything or hear.
No, I am saying don't hear it, my lord. I am
You are
not
saying don't hear it,
I am saying let the parliament hear it, my lord.
That's right. But therefore, we are trying to steer a middle course, which is that we don't want to first say that, well, we will decide
Lord,
everything.
when we are deciding
Then we
date of,
and then be confronted with this argument.
it has several windows have opened. I would, my lord, kindly on the lighter side and don't take otherwise. Several windows have already opened. Now they are trying to open the door, and I am saying that you will have to ultimately open your entire house.
Mr.
For example, the question is whether those
He is relying on those windows which have opened.
windows have got sufficient breeze inside or not is the question.
Now,
And-
another aspect.
And those windows are willy-nilly going to open whatever we decide, because society is not dependent on.
Lord, I must, my lord, say as a citizen.
Windows have opened up.
No, no, my lord, I'm saying as a citizen. I'm not saying yes or no. Societal acceptance of any relationship in the society is never dependent either on legislation or on judgments. It comes only from within. Let us accept it, whether we like to accept it or not. But leave it at that. That's my lord, more on my lord, other philosophical aspects. If your lordships are persuaded to take up special marriage act, possibly, my lord, on the ground that in one of the section the word used is spouse. My lord, my respectful submission is this, and kindly, a person, not a spouse. My lord, my respectful submission is this, and kindly, my lord, examine this correctly, a little, my lord, closely. Even special marriage act, and I will show, my lord, if I have to, my lord, at the a subsequent stage. The legislative intent of the legislature throughout has been a relationship between a biological male and a biological female, including special marriage act.
But Mr. Solicitor,
Number one.
there is a very important value judgment which you are making, that the very notion of a biological man is absolute, or that the notion of a biological woman is also an absolute notion.
Never change.
Which is incorrect.
The only biological man means biological man. It's not a question of notion.
Yes, of course it is. There is no absolute concept of a man or an absolute concept of a woman at all. That's
Lord,
not
I am-
in a broader context.
Biological man, my lord, means man only. It means, my lord, biological man. It's
Biological
not a
man is
matter
not a
of
definition
notion.
of what your genitals are. It's far more complex. That's the point.
Stop having rights if you're not a biological.
So even when the Special Marriage Act says man and woman, the very notion of a man and the notion of a woman is not an absolute. It's based on what genitals you have.
Not biological man means genitals you have. I didn't want to use that expression.
That's a point of view.
Another thing, for man, irrespective of other attributes than the genitals, there are separate age limits prescribed. Lord, what are we doing? See. No, that's not an argument. That's not an argument.
But we said it is not a mandatory thing that the whole society must accept something. Changes are always coming.
But the lordships will have to examine whether marriage is a fundamental right. Right to marry, divorce the law is a fundamental.
That's what I want to establish.
Lord, only a minute. Only a minute. Lord, I know my difficulties. Lord. I know my difficulties, but I am still discharging my duty. Lord, there are several acts. If the notion is treated to be a guiding factor to decide man or a woman, then I will show several acts which your lordships would unintentionally make non-workable. I may have, my lord, genital of a man, but if I am otherwise a female, my lord, as my lord possibly trying to be suggested, then, my lord, how would I be treated under the criminal procedure code? As a woman, my lord, can I be called? For 160 statement after a particular hour, I may say that this is only a notion. I may have a biological genitals of a man, but now I am a woman. Well, there are several issues, my lord, which have to be gone into, better they go into, be gone into by the parliament. And your lordships, my lord, kindly appreciate. But the parliament, we have good, eminent parliamentarians on both sides. And I can say this based only on my reading. Parliamentary committees are not acting the way in which, my lord, we see parliaments functioning. Parliament committees have all parties as members.
The lighter side, they say that real work is done in the parliamentary subcommittee.
Yes, yes. But they call witnesses, they call expert witnesses, they call stakeholders, they decide.
We have, both Justice Kaul and I, we have engaged with the department-related parliamentary committee. I chair the E-committee, Justice Kaul chairs NALSA. We have engaged extensively with the parliamentary committee. Our turn now to put those problems to Mr. Rodman.
Another aspect, but not another aspect.
We know where we are trying to find.
I'm fully confident. I'm fully confident. I'm fully confident. Only a minute more. Only a minute more.
Let me continue. I'm only saying they came with a broader canvas, much broader canvas. We are saying we are not willing to go into the broader canvas. We are not willing to go into personal laws. We are not willing to go into ABCD. Therefore, they have agreed to, for the time being, confine it only to the aspect which we are willing to rule on. And it cannot be said we must rule on everything. We are only willing to rule on that aspect. If that is the only remit which we are willing to consider, then actually their arguments or your arguments, you may have arguments whether it can be done under this act or not, whether even what is being sought to be canvassed by them should be left to the legislature to consider whether they would like to get into it. But the remit or the contours of the argument will thus have to be restricted only to the extent we are willing to consider the issue. It can't go.
I'll just give an example why I'm saying this. I'm just giving an example.
I will open to you to argue in response that don't go into even this limited realm. That is again.
I'm obliged. What has happened is this. In Navtej Johar, when the limited question was decriminalization of Section 3, X mentioned in 377, the central government very carefully filed an affidavit that we leave it to the wisdom of the court. We are not, but there we did say in no uncertain terms and recorded by your lordships that this is not an issue where we were even remotely touching about other issues of marriage, etc., etc. But as my lords have said, the window of marriage did open there. Now, today your lordships may not go into the question of personal laws, but the window of that personal law will open. Look, ultimately your lordships are dealing with her.
We cannot ever bind future generations after we are
exactly
gone.
My submission.
These are dusted and done.
Look, that's a
task for the future generations.
Look, that's from
whether it's the legislature or the court. I mean, we leave it open to.
Look, that's my. I'm not saying your lordship would bind. Your lordship would never bind. That's the majesty of the court. But your lordships not going it right now and giving some considering giving some relief would not mean that your lordships have never gone. That would, my lord, open another. That's all okay, my lord. That's okay. But ultimately, my lord, your lordship will have to consider this. Even Special Marriage Act does not prohibit. And entry 5 concurrent list is agnostic. It's not on personal law. It's a law of marriage. It's not Hindu marriage, Parsi marriage, or Muslim marriage. It's a law of marriage. It's their right to legalize, not to legalize, provide for many things, etc., etc. And therefore, my lord, again I am reiterating that my preliminary application, and there is a reason why I am repeatedly reiterating. My preliminary objection be taken up first, and your lordships may issue notice, my lord, to all the states. I am reiterating that request with a purpose, my lord, with an intent.
All right, we'll reflect on it at lunch and we'll take a call. Certainly we'll allow this.
May I have 2 minutes, Bruce?
Yes, Mr. Reddy.
Adopting everything which my learned solicitor says, Bruce. About the canvas, Bruce. So far as the Special Marriage Act is concerned, even if not this court, I'm assuming the lordships are inclined to update it or read in something in this act so as to accommodate the interests of the petitioner. Even then, the first of all, the preliminary issue would be whether the heterosexual unions with whom they are seeking equality. Mr. Rotagi himself said that if your lordship holds that they are equal, then the issue of reading in, etc. arises. Without first going into that question of equality, because it is going to be our strong submission, my lord, that there is no equality, my lords. It is one thing that they claim civil rights of different kind, with all sorts of consequences. Many countries, my lord, have had separate, my lord, enactments giving them certain recognition, certain rights. Even in UK, my lord, first there was a law enacted which gave them separately a right, and subsequently, my lord, this equality was granted by legislation. And therefore, my lords, the first and foremost question is, would this court be holding, Lord, because earlier in Navtej, your lordships never granted absolute equality, Lord, with heterosexual union. That was not the issue at all. So lordships have not educated us that no judgment should be read, Lord, dehorse the issues which had arisen in that case. In that case, Lord, the only issue was about the decriminalization, section 377, which in that context, your lordship made certain observations. Yes, as lawyers, Lord, we are entitled to rely on those observations and try to build further, Lord. But then that is not a final authority, Lord, for complete equality between the two kind of relations. One relation which has been existing, Lord, since time immemorial. Enormous continuity for heterosexual union. And that heterosexual union, my lord, as the lordship knows, is responsible for the perpetuation, the very existence of the human race, its perpetuation. Without it, my lord, the society itself will not live. The nations will not be there. But the other relationship, merely because there is love, affection, and concern and care, etc., that's just one part of the heterosexual union. That's not the core of the relationship. The very heterosexual union, this marriage amongst them, look, this institution is not the gift of law. It has been existing since Rig Vedas, and it's continued. The Manusmriti continued, Lords. And all religions, Lord, so basically, Lord, these marriages have evolved over thousands of years, Lords, and are based on usage, custom, religion, etc. And the core purpose was to perpetuate the human race. Without it, this relationship, Lord, it can't exist. You may have n number of other kind of relationship. Palanifrin refers to group marriages, polyamorous marriages, and so many things are existing, and this same-sex is not a new phenomenon. It had been existing earlier, and they never claimed equality. They were never given equality. That's a very important aspect. Go as far back as in history, they have existed, but not on an equal level. Today, under the Constitution, it is one thing that they want to claim. The question is, therefore, what I am trying to say is that this fundamental question, are they absolutely equal? Once your lordship comes to that conclusion that they are, then and then alone, Lord, the question will be, do we read it in this act itself without any necessity of declaring any enactment ultra vires and so on, Lords? And the second aspect is, Lords, that even under the Special Marriage Act, there are two aspects. If your lordship looks at one section, 19, good. On 19, section 19, Here, the two relations, the two unions are different, at different pedestal. Section 19, the manifests the Hindu.
Where are you reading, Mr.? 19.
I'm sorry, section 19.
Go ahead.
The marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh, or Jain religions shall be deemed to effect his severance from such family. So there is a consequence on the personal law. Well, there of course will be, they can say that it's my choice, I'm willing to.
Right, exactly.
That's fine.
This 21.
But then this,
21A follows. 21A follows. Not just 19, 21A. Amended it.
now further look. Degree of prohibited relationship. These are all, my lord, reflections of the personal law. What I wish to say, my lord, is that marriage amongst heterosexuals or the heterosexual union is not a gift of any of these laws. These laws are only regulating the long-standing blood relationship which has been existing in our society. They are only regulatory. Now kindly have section 4.
Subsection 6. It talks of biological man and biological woman.
Now kindly have 4B first. Neither party, and in fact in A the expression spouse itself is indicative of an heterosexual relation. That's of course a question of submission on merit. B, neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind, though capable of giving a valid consent has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children. So the procreation of children and the perpetuation of the society, Lord, and the race and the nation is an intrinsic idea, Lord, spelled out in this. Therefore, that question will have to be decided first. And even if you decide it is equal, whether your Lordship can still, Lord, read in be a submission on merit that is not possible even on merits, even if your Lordship holds that they are equal. And then see, the male has completed the age of 21 years and the female the age of 18 years. Now, how can, my lord, the question of man and women doesn't arise?
It's to be biological man and biological.
Yes.
Now, kindly have section 12.
So these
These are all arguments on merit.
It's on the merits, but I'm just briefly, not cursorily taking a lordship's.
No, this is an argument saying that don't do this, as the solicitor said, because it has various other ramifications. Even under the special marriage act, don't do it.
With respect, I'm saying I appreciate the fault from my lord, no, but I'm saying something else. I'm saying first, because of the historical submission which I made, because of these provisions, etc., and because of the fact that under this act, my lord, the states are empowered to make rules. Therefore, my lord, the states are absolutely essential party, necessary party, my lord, and no adjudication should be done without, my lord, issuing notices and pleading the states.
All right, we'll consider
Particularly, we have moved an application and I have not got an opportunity, so I must be, my application should be allowed, my lord, and given an opportunity. My lord. Thousands
Yes,
of
Mr.
people.
Bill.
2 minutes, only 2 minutes. Well, it's, at least some of us on this side, at least for speaking for myself, believe in the autonomy of the individual. And I think people are entitled to have a relationship of whatever kind, whether it's the same sex or not. I think that needs to be celebrated because that's the way society is moving forward. But having said that, assuming your lordships were to say it is a valid marriage, it's fair, your lordships can say that. Now, supposing the marriage breaks down, they've adopted a child, what's going to happen? Who's going to be the father? Who's going to be the tenant? Under procedural criminal law, who is the woman? Who will give maintenance? These are very, very serious societal consequences of that declaration. Either you take it as a whole or don't take it at all. I'm not averse to either. But if you do it piecemeal, it'll create more problems for that unity, for that union, for those two people, whether they're women or they are. In other legislations, when this has been done, if you look at the legislations around the world, they actually reform all the other laws in tandem with it. If you do it piecemeal, you will actually be hurting that very community. That's very dangerous. I am all for it personally, but I'm not in this fashion.
Why do you think do everything?
Either you do everything or you do nothing. But if you do it piecemeal, you're going to hurt that union.
You are representing which state? Sorry.
Well, I'm not representing anybody. In fact, I need not even argue because your lordships are leaving out personal law for Jamaat. So I need not even argue. But I'm just,
No, I just want
I
to
think
know.
an officer of the
Just to
court.
appreciate
I
the
just
submission, I wanted to know which is the group you represent. If you're not representing Jamaat.
I'm sorry.
Which is the group you represent? Which is the
The
stakeholder?
Jamaat, Malaj. Jamaat ulama. They're not parties. Therefore, Malaj, I am out of it, really, because your lordship has clarified it. I don't have to be here. But Malaj, I want to, no, just as having practiced here for so many years, I need to. Yes. Malaj, these are very, very complex, serious issues. If you decide it piecemeal, it's going to have huge ramifications. There'll be ghettoization. Imagine the impact in a village.
Mr. Sibbal, what we can do is that
Yes.
at the latter part of the arguments, we'd like you to assist the court for about half an hour or so. Please do.
Deeply obliged.
We come back.
To just take
May I have your lordship
response to what biological
There are certain other organizations.
For
example.
Look, we can't be hearing everybody to open their cases. What we'll do is now we've got a broad understanding of where the rival viewpoints are. We'll come back after lunch and now begin with Mr. Rohatgi's
Very well.
submission.
May I have your only thing what we wanted to say is not on the merits, but Lord, you are Bharatiya Sant Samiti, the Hindu chain. I'm not on that. I'm in the institution of marriage.
Now just one
the
thing
society.
on the logistics, Mr. Rohatgi.
Lord, I will finish by 4.
By 4 o'clock.
Yes.
Now, once you have covered this ground,
Yes.
I take it that the others will only make short supplementing submissions.
Yes.
Who will be leading? Dr. Singhvi, how long?
Dr. Singhvi, Mr. Kirpal wants to say.
Mr.
Dr.
Kirpan.
Singhvi, then Mr. Vishwanathan.
So, my lord, I'll just submit.
Give us a small
We, I'll,
Just give us a list of the order, set
I'll
out the orders, so
open.
that we can call out the names
Certainly.
one after the other. And we will take
What
it
we would
that
propose, my-
maybe all of you should be able to conclude by Thursday.
Very well, my
So
lord.
that we'll give you until the end of
Yes,
Thursday
Lord, I
for
think
the
that-
entire this
that
side.
would be
Fair
sufficient.
enough. And the following week we can, Malaj.
Even that I feel once you have addressed.
The others will have very short submissions.
Supplementing. I don't
Yes.
know if you finish today, how much supplementary can there be?
Not much.
Lord, I will place the relevant judgments which will establish according to me that we have a fundamental right, my Lord, to a marriage.
So
and to
perhaps
be
Thursday
solely-
afternoon, the others
Yes.
can start. I think Thursday afternoon, the rest of them can start.
And I'll get my choice.
Highly obliged.
But I would.
May I have a turn for a
Lord,
few
your
minutes
lordships
after?
are rejecting my application.
Mr. Solicitor, Mr. Attorney General?
Yeah, after lunch, a few minutes.
Yes,
your lordship's
after
time.
lunch.
Very.
We're highly obliged.
Lord, I am not replying piecemeal to these submissions just now.
No, you can now
I
start.
want to proceed,
You can open.
Lord,
Yes.
on what I want to
Absolutely.
say. Then, Lord, I'll deal with this briefly, these interventions. So, my Lord, I want to first establish that we have a fundamental right, my Lord, to get married, have it recognized by the state, and have it registered like our brethren in the heterosexual majority group in society. If, my Lord, we are right, then, my Lord, certain rights flow from that status of marriage. Some of it was being explained, my Lord, like pensions, like, my Lord, there are some income tax provisions, gifts, many other things apart from status in society. That is most important. Lord, I was amazed to hear the other side saying, my Lord, that we are not equal. I heard this submission, that we are not equal to the brethren of the heterosexual group. It's an astounding statement coming, my Lord, from a state. The Constitution does not make two classes of citizens, my Lord. It makes only one class, people of India. Let us start, my Lord. I am amazed to say that we are not equal, as if we must continue to be treated as those, my Lord, who are tainted or stigmatized. That is the mindset today. That mindset continues. And therefore, it is important for this court to step in. Because, my Lord, it has removed one obstacle of 377. But after that, where? That stigmatization continues. And this, my Lord, is reflective of the stand being taken by no less than a state, that where is your equality? Where are you equal? My Lord, let us first start very briefly to have a look and remind ourselves on the preamble of this Constitution. My friend said, how are you equal? We became equal in 1950. Have a look at the preamble. And then, my Lord, I will shortly show the discussion on the preamble in Puttu Swami, in the opinion of his Lordship, my Lord, Justice Chandrachud. But first, I will show to your Lordship, my Lord, the preamble. And your Lordships know, my Lord, preamble was held to be a part of the Constitution in Keshavan Bharati. It is intrinsic to the understanding of the ethos and the philosophy of the Constitution. And, my Lord, all these articles 14, 19, 15, 21 really flow, my Lord, or are adjuncts of this preamble. Kindly see, my Lord.
Fundamentals are mentioned here.
We, the people of India, having solemnly resolved to constitute India into a sovereign, socialistic, secular, democratic republic. We are more concerned with secular in the context in which we are placed, my Lord. To secure to all citizens justice, liberty of thought, expression, belief, faith, and worship. See the articles, my Lord, which will be involved in this. Liberty of thought and expression, Article 19, Article 21 also, because the right to have dignity to live a full life. Faith and worship, religion, secular, pluralistic. It will go to Article 25, 29. Equality of status and opportunity. The implementing provision will be 14, 15, and 16, which are, my Lord, a triangle. Not the golden triangle, but a triangle between themselves. 14, 15, and 16. And then to promote among them all fraternity. So justice, liberty, equality will allow, my Lord, promotion of fraternity. Fraternity, my Lord, is brotherhood, community interest, assuring, these words are prophetic now, assuring the dignity of the individual. Now, my Lord, this dignity sits in Article 21 in terms of Puttu Swami. Dignity, an adjunct of privacy. It sits in Article 21. and the unity and integrity of the nation. This is very important. So it is not, my lord, only dealing with these individual rights. It says that justice, liberty, equality will promote fraternity. What will it do? It will assure the dignity of the people of India or the citizens of India, give them the full panoply of rights under Article 21 and 14, 19, etc. And the unity and integrity, my lord, unity and integrity is a far higher concept than mere individuals. So it will coalesce, my lord.
Actually,
will have-
Mr. Dradgi, there are two words in the preamble which have not been dealt with too often, which is and to secure to all of its citizens.
Yes, yes.
The first part says to secure to all its citizens.
Correct. I'm grateful.
Secure means to enable them to have the protection of or enjoyment
Yes,
of these
yes,
values.
yes.
So this
Affirmatively.
is- right, affirmative.
My lord, affirmatively.
And that is individual.
Yes.
Now the latter part says and to promote among them all. That's very important.
All, my lord.
So it goes beyond the individual.
Yes, all means the entire society, which consists, my lord, of citizens having different views, different hues, different color, different religion, but we will treat them under one umbrella. They will form, my lord, and forge the unity of this nation. Why was unity important? Because we had just come after a partition. So it will forge, my lord, all people together as one unit, but having dissimilarities. And the pluralistic or secular society accepts and understands diversity, plurality, multilingual, multi-faith, multi-religion, multicultural. That was the concept, not.
So justice to each of us, liberty to each of us, equality to each of us, and fraternity among us.
I am grateful. I am very grateful.
The important
So, my lord, individual, community,
Rodgi.
citizens, and the nation. This is the sweep. Sorry, my lord, I am so very sorry.
Important expression here, which connects at the lowest level to the unity of the country, is the individual.
Yes,
The individual to the nation.
correct. I am very grateful.
In the context of dignity is connected to individual.
Yes.
And unity is connected.
How will you have unity?
Citizens alone.
Yeah.
An individual is a very
Nothing on merits. The artificial intelligence has changed Mr. Rodgi into Dr. Singhvi. Your arguments are recorded as Dr. Singhvi's arguments.
Oh, please
Be
correct me.
cleaned up by the evening. By the
Please, I will correct it.
No, you get more memos.
I may get more briefs if it is my argument, not somebody else's.
I don't think either of you need too many more briefs.
He said in a lighter vein. Your Lordship is right, not. We start from the individual, community, forge the integrity of a nation. How can you do it when you say that these individuals are not equal? We are born with this. I am pained to read, which is touted in the paper every day, that this is an elitist concept. This is what the affidavit of the application says. Every newspaper carries it, Lord. That this urban elitist concept. When I was doing some research, I found that Nero, the Roman emperor, in AD 54 or 58, he married twice, two men at that time. And he told the imperial court, please recognize this marriage. My Lord Justice Chandrachud referred to the origin of Lord Ayappa. I found it very interesting. I have read it. How was Lord Ayappa born? My Lord, a union of two gods, Lord Shiva and Lord Vishnu, but Lord Vishnu in the role of Mohini. I mean, it's very, very interesting, my Lord. Therefore, nothing is absolute. The solicitor talked about, my Lord, the transgenders. Transgenders is only T out of LGBT. It's only T. LGB is not considered, my Lord, with the transgenders. So therefore, my Lord, these concepts change. I also heard him say, whether the court decides, whether parliament decides, doesn't matter. It's the society which decides, something like that. We will take the Hindu Widows' Right to Remarriage Act, 1860 something. The society was not ready, my Lord, for widows' remarriage till even early 90s. You have those widows' houses, my lord, in Mathura.
Before 1956, bigamy was not.
My lord, my lord. But, my lord, the Dominion Parliament in the 1800s moved far ahead of the society and allowed, my lord, the Hindu widows to remarry. But sometimes the mindset still don't change. It didn't change, my lord, even till early 1900s, even till 1920, 30s, and you have those homes, my lord, in Mathura. So sometimes, my lord, Parliament or the Legislative Assembly acts with more alacrity. Sometimes it acts, my lord, with less alacrity. But here, we have moved on. We have moved on. Your Lordship's declaration to remove, my lord, the obstacle in our way from achieving all this was only one. That is, insofar as the state is concerned, was 377. The second is the mindset. And all this which is argued is actually reflective of that mindset. Heterosexual majority is the only one. That's the only way life is. That's the only way it should be. That's the only way it should be seen. And that is the only way, my lord, marriage must be seen. That, my lord, with great respect, your lordships have said that the majoritarian way must give way to the constitutional freedoms. Can't be that what majority is doing is correct and therefore you squash the rights of the others. All this is, my lord, a part of the judgment which I quickly showed to your lordship. I am not adding anything, my lord, except this, some research I had done, my lord, for all this. But otherwise, this is all, my lord, documented.
Society today.
No, my lord, my friend is right. See, my lord, the Chief Justice referred to this fact. Navtej came, my lord, 5 years ago. In 5 years, we have seen a perceptible difference as to how people view, my lord, people of our community, if you call it that way. Not fully. Some stigma is still there, as I said, in public spaces, etc. That stigma can only be removed by a declaration of the court, just as we had a declaration in Navtej. We'll not see one more thing. It's not only our rights. Look at the rights of our parents. I don't know if your lordship read or not. I read an article
By Mr. Vivek Arju. I was
Yes.
going to say that, yes.
I read the article by him.
In the Indian Express.
Yes, I'll pass it on to your lordship if it is not there. I read an article. So rights of others are also involved. Rights of parents, how to treat their children, how to treat them in their society, that is the elder society, in their fraternity. People ask me, Lord, what do your children do? Where are they? Etc. etc. So the rights of others, that is, my lord, one below and one above. Children and the parents. So rights of many, my lord, are under interplay when you are deciding, my lord, the rights of these people. That's how, my lord, it carries on. Now, my lord, we go straight to judgments. I've read the preamble. Now, no, I'll go to that. Now, my lord, your lordship may note one or two things I will not read because they are well known. And then we will go straight, my lord, to Nalsa, which is the first of this lot. But just make a note, my lord. Secularism was held to be a part of the basic structure in Bombay. My lord, we note the page. I don't want to read it, my lord. It's well known. Secularism was held to be a part of the basic structure in Bombay. 1994, 3 SCC, page 1, paras 145 and 153. Then, my lord, it was also held to be such in Coelho, which is 9 judges, Justice Sabharwal, speaking for the court, 2007, 2 SCC, page 1, paras 106 and 109. And just as an aside, my lord, those of who were in this court at that time, Justice Sabharwal said, my lord, we will start the case on Monday at 10:30 and end it on Friday at 4:30 or 4 o'clock. This 9 judges case. And it was actually so finished. No miscellaneous, my lord, some of us who were here would remember, my lord. This is how it happened. Anyway. Then, my lord, please note, para 1 of TMA Pi, which is, my lord, 11 judges, if I am not mistaken. Chief Justice Kirpal, 2002, Volume 8, SCC 481, Para 1, only the first line that India is a land of diversity.
He
So-
uses the expression mosaic.
Yes. Grateful. Diversity, plurality, secularism, all this means that people who are constituting, Lord, the unity of that nation must move together. They must move together. They are not unequal. That's why
Back to
do away with.
Justice Das,
Sorry.
in Kerala Education Bill.
Yes.
That too is the first paragraph.
Right. 56
58.
to 58. So now, my lord, we go straight to Nalsa. So I have to now read passages of 4 or 5 judgments.
And we have followed this principle in Ayodhya as well.
Yes.
In
Yes.
fact, Ayodhya, we said that the 1993 Act was an
Yes, my
expression
lord.
of the
Yes.
basic structure.
But my lord, I wanted to concentrate on this line. Rather, so Nalsa, Puttuswamy, Navtej, Shafin, Deepika. That's, my lord, the line which I wish to take. It's all, my lord, said by lordship. So we go straight to Nalsa, my lord. It's a part of the compilation, my lord, which is on the lordship's mail. Is it on the mail?
Yes, it's with them. Volume 1. It's with them. Volume 1.
Page 711 of volume 1.
Your note, your
Yeah, yeah, yes, yes.
Page?
My lord, it is page 711 of volume 1 of the compilation.
42 PDF. It starts at 7:38.
When you folder document volume 1.
Lordship's words.
What's the meaning?
Guy President Folders.
Yesterday evening, on this.
Oh, the law clerks will assist me.
Nalsa.
No, it's
I have a vested interest in ensuring that justice call also is on the
I
electronic
know.
format.
Since there is a small interlude, I must thank all my learned
Yeah.
friends who worked very hard to put
Yeah,
this.
I very
Yeah.
often use the stylus.
Almost 20 or perhaps 25,000 pages. And due to my error, they had to do it twice. So they have, I must thank them for the effort they've put in to get these compilations.
I can blame it on the laptop. You
We are
can give
finding
it
it
to
out.
me so time doesn't rely. In the meantime, they'll find out.
solicitor, you can give till they find it. You can give.
or you can use
Lordship is saying you give till they find it on that.
Got it.
Page 742. no?
Volume
Page 742 and of the PDF pages.
7.
ये नोट में
You punch in 742.
इसी में
Not 742.
742.
That's ऊपर करना है ना.
Yes, 738.
yeah correct.
Chief Justice wants to make sure I am doing it by the time I demit office.
No, my learned brother has been a real sport. He's yesterday he spent the whole evening on this.
On the lighter side, I was telling him the only thing in this is that you don't have the pleasure of throwing the file down.
We'll have to go to the volume. Miss
What I
Karthik,
call-
which volume is this?
My lord, I was wanting to read 738, para 21.
This would be volume 2.
Sorry.
Volume 2.
Volume 1
No, my lord.
Volume 1
of the
contains
precedents.
precedent,
Precedents.
Number 6.
because it runs into some 20 whatever thousand pages, right?
And what is the para number?
My lord, para 21, the heading is gender identity and sexual orientation.
Got it.
Your Lordship. My lord, page 465 of the report.
21.
Justice Bhatt gets it.
Yes, yes. Please go on. It's all right.
I'll start. Gender identity is one of the most fundamental aspects of life, which refer to a person's intrinsic sense of being male, female, or transgender or transsexual. This case was concerned not with transgenders or transsexual. A person's sex is usually assigned at birth, but a relatively small group of people may be born with bodies which incorporate both a certain aspects of both male and female. Then, my lord, it goes on. Your Lordship sees the last line of that para. Gender identity therefore refers to an individual's self-identification as a man, woman, transgender, or any other identified category. Sexual orientation refers to individuals enduring physical, romantic, emotional attraction to another person. Sexual orientation includes transgender and gender variant with heavy sexual orientation, and their sexual may or may not change during or after gender transmission, which also includes homosexuals, bisexuals, heterosexuals, asexuals. Gender identity and sexual orientation, as already indicated, are different concepts. Each person self-defined is sexual orientation and gender identity integral to their personality and is one of the most basic aspects of self-determination, dignity, freedom, and no one will be forced to undergo a medical procedure, etc., etc., etc. So the importance is not each person's self-defined sexual orientation, gender identity is integral to their personality, one of the most basic aspects of self-determination, dignity, and freedom. This is now translated in Puttu Swami, my lord, as a part of Article 21. This itself. Then your lordship sees
Page 760.
my lord, page 760.
487 of the.
Page?
Page 760, my lord, of the compilation. 487 of the report.
760, yes.
Para 61.
Yes.
This is on Article 14. If your lordship sees last 4 lines of para 61. 61 does not restrict the word person and application only to male or females. Hijras, transgenders, who are neither male, female, fall within the expression person and hence entitled to legal protection of laws in all spheres of activity, including employment, healthcare, education, as equal, etc., etc. Would your lordship just see the first part also? Yes, I should have read. Article 14 states that state shall not deny to any person equality before the law or equal protection. Equality includes full and equal enjoyment of all rights and freedoms. Right to equality has been declared as a basic feature of the Constitution, and treatment of equals as unequals and equals as unequal will be violated. So equality in the preamble, equality as reflected in Article 14 is also, my lord, a basic structure, just like secularism, just like judicial review, just like rule of law, and some other aspects. My lord, last line of that page, discrimination on the ground of sexual orientation or gender identity therefore impairs equality before law and equal protection of laws and violates 14. Your lordship turns to the next page. Para 63. Article 15 and 16 prohibit discrimination against any citizen on certain enumerated grounds, including ground of sex. In fact, both articles prohibit all forms of gender bias and gender-based discrimination. 15 states, state will not discriminate against any citizen on the ground of sex, etc. Then come to 66, my lord. 15 and 16 sought to prohibit discrimination on the basis of sex, recognizing that sex determination is a historical fact and needs to be addressed. Constitution makers can be gathered, gave emphasis to fundamental rights against sex discrimination so as to prevent the direct or indirect attitude. This is important. So as to treat the direct or indirect attitude to treat people differently for the reason of not being in conformity with the stereotypical generalization of binary genders, Both gender and biological attributes constitute distinct components of sex. Biological characteristics, of course, include genitals, chromosomes, secondary sexual features, but gender attributes includes one's self-image, deep psychological and emotional sense of sexual identity and character. The discrimination on the ground of sex under 1516 therefore includes discrimination on the ground of gender identity. The expression sex is not limited to a biological sex of male or female, but intended to include people who consider themselves to be neither male nor female. This then found its way, my lord, in Anuj Garg, that, my lord, employees of a hotel, whether you could, this find, my lord, mentioned in Anuj Garg. No, but the same thing is in Anuj Garg. Same thing is in Anuj Garg. Though Anuj Garg was earlier. Justice Sinha speaking for the court. Same thing is in Anuj Garg. And what your lordships have, my lord, discounted is the view of Nargesh Mirza. My lord, next page. Second line. State is bound to take some affirmative action for their advancement so that injustice done to them for centuries could be remedied, etc. Then, my lord, 19(1)(a), para 69, just above placetum E. Article 19(1)(a) states that all citizens will have the right to freedom of speech expression, which includes one's right to expression of his self-identified gender. The self-identified gender can be expressed through dress, words, actions, or behaviors. So expression is not limited to, my lord, speaking, speech, or reading. The self through dress, words, actions, no restriction can be placed on one's personal appearance or choice of dressing, subject to restrictions contained in 19(2). My lord, the next page, 763, page 490 of the report. Para 71. The principles referred to above clearly indicate that freedom of expression guaranteed in 19(1)(a) includes freedom to express one's chosen gender identity through varied ways and means by way of expression, speech, mannerism, clothing. Gender identity, therefore, this is important, lies at the core of one's personal identity. Gender expression and presentation, therefore, will have to be protected. Under 19(1)(a), a transgender personality could be expressed by his behavior and presentation. The state cannot prohibit, restrict, or interfere with the transgender's expression, etc., etc. Then, my lord, para 73, Article 21. After the quotation, Article 21 is the heart and soul. The Constitution which speaks of the right to life and liberty. Right to life is the most fundamental. Not even the state has the authority to violate. Article 21 takes care of aspects of life which go to make life meaningful, protects the dignity of human life, one's personal autonomy, one's right of privacy. These are prophetic words which ultimately came, my lord, in Puttaswamy. Right to dignity is recognized as an essential part of the right to life and accrues. Francis Corali Mullin, this court held the right to dignity forms an essential part, and, my lord, is not only mere existence, that your lordship said. That then 74. Recognition of one's gender identity lies at the heart of fundamental right to dignity. Again, now Article 21. Gender is already indicated constitutes the core of one's self-being as well as an integral part of an identity. Legal recognition of the gender is therefore a part of the right to dignity and freedom. Again, my lord, re-emphasizing Article 21. And then 21, my lord, his lordships talk about Anuj Garg, etc. Lord, para 82 on the next page is the same, but I don't wish to read it. Now we go to Puttaswamy. Puttaswamy, my lord, in the same volume,
Page 63.
at page, starts at page 63 of the compilation. Your lordship sees, my lord, the opinion of his lordship Justice Chandrachud, as his lordship then was, at page 407 of the compilation, 345 of the report. Your lordship will find, if your lordships get that, if all my lords have it, my lord.
Yes. Just 1 second.
My lord, 407 of the compilation, 345 of the report.
para is it?
My lords, get it?
What para is it, I said?
My lord, it starts at 407, page 345 of the report.
Page starts at page.
I want to go straight to the expounding of the preamble at 464 of the compilation and 402 of the report.
Yes.
Para is 105. Para 105. 106 is Sajjan Singh. Now see 107. Keshavananda Sikri CJ noticed that the preamble is a part of the constitution because there was a debate on this. Is it a part? Is it a preface? Etc. etc. The preamble emphasizes the need to secure to all citizens justice, liberty, equality, fraternity. Together they constitute the founding faith or the blueprint of values embodied with a sense of permanence in the constitutional document. Preamble speaks of securing liberty of thought, expression, belief, faith, worship. Fraternity to be promoted to assure the dignity of the individual. Individual is at the core of the focus ideals of justice, liberty, equality. Animate the vision of securing a dignified existence. So, my lord, actually, if you read the preamble and these 2-3 paragraphs, Article 14, 15, 16, 19 and 21 all will form, my lord, all will form a part of one whole. The Lordship said, my lord, referred to the preamble. And as I said, my lord, in the opening, all the phrases in the preamble are significant because they appear in their avatars as 14, 15, 16, 19 and 21. That's the importance. Equality, justice, fraternity, liberty of thought, expression, all these forms, my lord, is in 14, 15, 16, 19 and 21. Now, my lord, your lordship talk about jurisprudence on dignity in para 108. 108. This is on dignity and the importance of dignity. Third line, the constitutional vision seeks the realization of justice, liberty of so and so, so and so, equality as a guarantee against arbitrary treatment, and fraternity, which is, my lord, dignity. Then para 110, Francis Corali Mullen, where your lordship said mere existence is not life. That, my lord, is reflected in paras 7 and 8 of Francis on the next page. Bandhua Mukti Morcha, to the same effect. What is life? What is dignity? Then, my lord, para 119 at 468. To live is to live with dignity. This is very important. Dignity and life must coexist. One without the other is no good. The draftsmen of the Constitution defined their vision in society, which constitutional values will be attained by emphasizing, amongst other freedoms, liberty and dignity. So fundamental is dignity that it permeates the core of the rights guaranteed to the individual, part 3. Dignity is the core which unites the fundamental rights, because the fundamental rights seek to achieve for every individual dignity of existence, privacy with the attendant values, assuring dignity and you. Only then life can be enjoyed with dignity, can liberty be of true substance. So if you don't have full enjoyment of life, you will not have, my lord, full dignity. Yes. Then, my lord, paragraph 144, it's marked here, at page 483 of the report. This is very important, my lord, for the majoritarian group within the society and the minority group. Para 144 is critical, my lord, for my purposes. Neither of the above reasons also, that a minuscule fraction of the country's population constitutes LGBT, as observed, is not a sustainable basis to deny the right to privacy. The purpose of elevating certain rights to the stature of guaranteed fundamental rights is to insulate their exercise from the disdain of the majorities. This is what is happening to us. We are facing this disdain. We are facing this stigma. Whether legislative or popular, the guarantee of constitutional rights does not depend on their exercise being favorable regarded by majoritarian opinion. The test of popular acceptance does not furnish a valid basis to disregard rights which are conferred with the sanctity of constitutional protection. Discrete and insular minorities face grave dangers of discrimination for the simple reason that their views, beliefs, and way of life does not accord to the mainstream. I respectfully submit, Milad, this is the core of my argument. Because we are minuscule, because we have faced this over the years, because we have been sidetracked, because we are looked at with disdain, because we are looked at with, my lord, unpopular feelings, because we are looked as squares. That's why the word queer. You are different, you are queer. And you were subjected to 377. You are no good. You are no good. That's how it was. That no good, my lord, is removed substantially by 377. But what about the stigma in place? As my lord Menka said, what about the stigma which is going on? In workplace, here, there, pension, we are facing that stigma. That can only be removed by a constitutional declaration by the highest court of the land. That my rights are equal to those of the others. They have a right of marriage, unit of family, respectability, plus a concomitant of rights which flow from that respectability. The same thing should accord to me. And I should not be discriminated only because, my lord, we may be 10,000 and the others may be 10 crores. This is the core, my lord, of my submission. Then, my lord, next page. Last line, my lord, of that page. I have to read this paragraph. Yet in a democratic constitution founded on the rule of law, their rights are as sacred as those conferred on other citizens to protect their freedoms and liberties. Pausing here, my lord, it is argued on the other side. We are not equal. As if we are back in the 30s or 20s or 1800s, that you are lesser mortals. So don't talk about rights. Don't talk about marriage. Live the way you are. Be happy that 377 is gone and be done with it. That, my lord, is the approach of the majority which is being reflected by the other side. Sexual orientation is an essential attribute of privacy. Discrimination against an individual on the basis of sexual orientation is deeply offensive to the dignity and self-worth of the individual. Equality demands that sexual orientation of each individual society must be protected on an even platform. Very important, the phrase is even platform, not an uneven platform of equals and unequals. The right to privacy and protection of sexual orientation lies at the core of fundamental rights of 14, 15, and 21. There can be no doubt now, my lord, that my rights, which will ultimately now, this will be followed by Navtej. So reading this and Navtej will make it clear that the rights of all, including my clients, in full exercise and enjoyment of their rights in 14, 15, 16, 19, and 21 must be the same as that of the others. And therefore, the next logical step after removing 377 is the cherished object of marriage, family, and a unit in the society's order. And that, my lord, will give us other rights which we are talking about, whether larger issues, smaller issues, but those, my lord, will give us. But it gives us respectability. It's not only a case of, all right, no 377, but you live the way you want. Live the way you want in your house. Don't come outside. Because if you come outside, the majority will look at you with disdain. That has to be removed, my lord. And when your lordships do it, it has the same effect of law as Parliament by virtue of Article 141. And it is no answer ever to tell, my lord, a constitutional court, which is the guarantor of fundamental rights. My lord, last 70 years it has been said that this court is the guarantor of fundamental rights. It is no answer to say that even if one man comes and complains of his violation, my lord, of fundamental rights or an enforcement of fundamental rights, you better wait for Parliament. No answer. No court has, this court has never accepted that answer. 32 is itself a fundamental right. I have a right to come to the court and complain. My fundamental right is being violated, not followed, not being implemented. And this court must come to my aid. Need not be a group. Maybe the whole, my lord, the population may be against me, but I have that right. And I cannot be told, with great respect, I submit, my lord, in humility, that I must wait for Parliament. Somebody should then enact after I am dead and gone. Then, my lord, 145. When your lordship, my lord, reverse Kaushal, last 4 lines, my lord, of 145. The rights are not so called, but are real rights founded on sound constitutional doctrine. They inhere in the right to life. Again, 21. They dwell in privacy and dignity. Now a part of 21, my lord. They constitute the essence of liberty and freedom. Sexual orientation is an essential component of identity. Equal protection demands protection of identity. So real rights, that people should not look at me with disdain. People should not say you are queer. People should not say let's not be friends with you. Then, my lord, that is Kaushal. My lord, 146. The decision in Kaushal presents a de minimis rationale when it asserts that they have only 200 prosecutions. This is an argument of minuscule against the majority. Kaushal went on this, my lord. So very small people, very small group. How does it matter? Why should it bother? The de minimis hypothesis is misplaced because the invasion of a fundamental right is not rendered tolerable when few are opposed to large number of people. This is the minority versus the majoritarian rule. No steamrolling. No steamrolling of ideas, faiths of one major group over, my lord, a small. Otherwise, my lord, look at religion. It will lead to religious persecutions. Suppose in a country, my lord, the majority is of one religion and you have small other religions. If you go by majority, you will steamroll the other religions. The moment you do that, you lose being secular. You lose, my lord, being plural. So our constitution has guarded against it. Be diverse, yet be Indian. Be whatever religion you have, but you are an Indian. Whatever faith you profess, whatever language you speak, no matter your card or your creed or your caste or your place of birth. The constitution intends to raise all this, my lord, from the times of 1800s and the deprived to today to be a forward-looking, my lord, community. Then, my lord, in para 147, your lordships leave the issue of my lord, naftage. Now, my lord, kindly come straight to page 558. Para starts, my lord, at 294. Then, my lord, it talks about, my lord, violation of law, fundamental rights. See, my lord, 297. Essential nature of privacy. Essential nature of privacy. Second line of that para.
Just one second.
The ability.
One second.
195.
559, at the foot is para 297. Yes. Without second line, placidum G. The concept is founded on the autonomy of the individual. The ability of an individual to make choices lies at the core of human personality. Choice, notion of privacy enables the individual to assert and control the human element, which is inseparable from personality of the individual. The inviolable nature of human personality is manifested in the ability to make decisions on matters intimate to human life. These words echo today. Choice, my lord, of human lives, choice of people. It's not, my lord, an elitist concept. It is, my lord, innate, with which people are born. So was Nero born, and thousands of years ago. Autonomy of the individual is associated over matters.
On Nero.
Sorry, my lord.
Let's not model ourselves. Sure.
You're right, my lord. You're perfectly
Last
right.
thing he fiddled.
We can't model ourselves on Nero.
Of all the
Nero said this when Rome is.
There are enough examples in
He was saying that
We
when
can't-
Rome was burning. my
I
lord.
say we can't fiddle.
Yeah. Then, my lord, between placidum A and B at page 560 of the report, without the ability to make choices, the inviolability of the personality will be in doubt. One line later. Privacy is a postulate of human dignity. Thoughts and behavioral patterns which are intimate to individuals entitled to a zone of privacy where one is free of societal expectations. In that zone, an individual is not judged by others. Privacy enables each individual to take crucial decisions which find expression in human personality. It enables individuals to preserve their belief, thought, expression, idea, ideology, preferences, choices against, please mark, my lord, very critical, against societal demands of homogeneity. So no steamrolling. Privacy is an intrinsic recognition of heterogeneity or the right of the individual to be different and to stand against the tide of conformity in creating a zone of solitude. Privacy protects the individual from the searching glare of publicity in matters which are personal. Privacy attaches the person not to the place where it is. Privacy constitutes foundation of all liberty because in privacy, an individual can decide how liberty is best exercised, etc., etc. So this is the tide of the majority which is stigmatizing me, my lord. Today it can't criminalize me because of a lordship judgment. It can't criminalize me like Mr. Thomas was criminalized, my lord, in America. When the police came and knocked on the door, it was a police raid. They found, my lord, he was indulging in that act. And he was charged by University of that law of Texas. I can't be criminalized, but the stigmatization continues. My lord, last 10 lines of that page in para 298. The autonomy of the individual is the ability to make decisions on vital matters of concern to life. Privacy has not been couched as an independent fundamental right, but that does not detract from the constitutional protection afforded to it. Once the true nature of privacy in relation with those fundamental rights which are expressly protected and understood. Privacy lies across the spectrum. The guarantee of equality is a guarantee against arbitrary action. It prevents the state from discriminating between individuals. The destruction by the state of a sanctified personal space, whether the body or mind, is violated the guarantee against arbitrary action. Privacy of the body entails the individual to the integrity of the physical aspects of it. The intersection between one's mental and integrity and privacy entitles the individual to freedom of thought, freedom to believe in what is right, what is wrong, etc., etc. My lord, just between placidums B and C, the freedom under 19 can be fulfilled where the individual is entitled to decide upon his or her preferences. Read in conjunction with 21, liberty enables the individual to have a choice of preferences, etc., etc. Sorry, Milord, I missed one line. See the third line on top. Family, marriage, procreation, and sexual orientation are a part of dignity, and dignity is a part of 21. So what I am requesting your lordship to grant me a declaration is a declaration of my right under 21. That's what I am respectfully submitting. And procreation in, my lord, today's scenario can also include adoption, IVF, surrogacy, need not only be procreation in one form.
I think family comprehension.
Yes. And my lord, again, I have read that lesson. Now, my lord, 299, first line. Privacy represents the core of human personality. So, privacy, dignity to lead a full life, full enjoyment, sits in Article 21. And therefore, my lord, my request to the court is a declaration of my right under 21, read with 19 and the troika of 14, 15 and 16. Then, my lord, page 569 is the conclusions. Where MP Sharma Millet is overruled at 316. Your Lordship would recall, my Lord, MP Sharma was 8 judges. That is why it was sent to 9. And when before 5 it was argued, my Lord, I was on the other side. I showed, my Lord, MP Sharma to 5 judges. And then 5 judges had to send it to 9 because
I was
of...
at that time arguing before 3-judge bench
That's it.
defamation case. And I was arguing privacy is an integral part. So as Attorney General, he came to me and said, Narasimha, I argued there is no privacy. What are you doing here?
So, my Lord, I showed from MP Sharma, there is a direct line that there is no concept of privacy in the Constitution. That's what MP Sharma said.
That is why you got it referred.
That's why, my Lord, it was referred to. But by that time, my Lord, I had left that side and come to this side.
As I was reading all these paragraphs, I was remembering what you were arguing and how so fondly you were reading paragraph after paragraph, which is what I was arguing there before Deepak Mishra.
Mr. Attorney General, your predecessor ensured that the privacy reference ensured that the Aadhaar decision was substantially delayed, you see. So the stack to ensure कि
My Lord, Khadak Singh, etc. My Lord, see para 321, page 570. This is critical for another reason. And I want to read this. Judicial recognition of the existence of a constitutional right to privacy is not an exercise in the nature of amending the Constitution, nor is the court embarking on a constitutional function of that nature which is entrusted to Parliament. It applies on all fours to my case. So this is one paragraph.
321.
321, my Lord, is very critical for my purposes to counter the argument. Let us wait for Parliament to do something and the court should, my Lord, keep its hand off. That, my Lord, is answered in 321, applies on all fours. And this is the judgment, my Lord, of 9 judges, squarely binding, my Lord, on this bench. And the same thing, my Lord, I will show from Justice Nariman's view in Shairaban. Same thing. But that this is 9 judges, my Lord. That's the import of this case. 321 is directly binding me. Privacy postulates a bundle of entitlements and interests which lie at the foundation of order and liberty. My Lord, 323 is very important again. Again on plurality and the majority. 323, my Lord. Para. Privacy includes at its core the preservation of personal intimacies, sanctity of family, marriage, life, marriage, procreation. Please underline marriage. These are prophetic to my case today. I am arguing a case of family.
It's slightly more perhaps because it is not only 21. This is in the context of expounding 21. You want to exercise freedom of association.
Yes.
Now, whom do you want to? What do you want to speak?
Yes.
What you speak here and what you speak at home is going to be different. So there is an intersection of privacy in the exercise of every right.
19.
Autonomy
Article
and
19.
privacy go hand in hand along with the exercise of every right.
Yes.
And not just 21 rights.
I appreciate. My right is bolstered by aspects of 19 which your lordship are expounding. But see this blood. Sanctity of family, life, marriage, procreation, home and sexual orientation. What else am I wanting? It is already granted. That's why I said, blood, I'm not reinventing the wheel. It's all here. I'm only putting it together. Because there was no question of marriage in those cases. But I'm only putting it together. Really speaking. So privacy, my lord, is found in this judgment, not only in one article. It is found on terms of, it is found in 21 finds dignity, privacy and dignity go together. It is found in 19(1)(a). Also, my lord, C, associations. That may be another concept of associations, not the original concept of forming an association, like a society or this, that. Associations, right to form an association between individuals, between groups.
No. Exercise of freedom of association itself may involve
Yes.
the choice, exercise, the right to privacy, because what you do in an association.
Yes, of course.
You may not want everyone else to know what you're doing.
Yes, absolutely. Then 326. 326. Privacy has both positive and negative content. The negative content restrains the state from committing intrusion upon the life and personal liberty. The positive content imposes an obligation on the state to take measures to protect the privacy. I'm wanting, my lord, a positive content from them. You want, frame the law. But if you don't frame the law for marriage, the court will set in, and the court's order will be, my lord, a protection, an affirmative protection of my right.
Just to, as an
That in 1954. In 1954, there was no constitutional declaration of what I'm wanting. Just as there was no declaration of the Constitution for dignity. So if I get the declaration at the top level, then the statutory level under the Constitution, Lord, is subservient, Lord, level. This must give way and, Lord, adapt itself to the head. If this is the sun, This is something else. This must accord with the sum.
Very easy to defeat my rights.
Otherwise, you defeat my right by saying, I won't give you a constitutional declaration even if you are entitled to, because a statute, when made in 1954, was not in accord. It has to fall in accord. So there is no gainsaying that look at the act. Obviously, the act will not never contemplated in 1954. We also know that. Therefore, I am not wanting, my lord, merely an amendment to the act without the declaration. Because if your lordships only interpret, my lord, the act, tomorrow it can be amended by parliament. Then we are sunk. So I want first, or I request, not want, I request a constitutional declaration of marriage akin to that of the heterogeneous group. Once I get the declaration, then, my lord, the law which is in existence in 1954 must fall in place with that declaration by a method of purposive interpretation. That's how, my lord, this I have done that. Now, my lord, we go to one para, my lord, of Justice Nariman. Yes. That, my lord, your lordship will find
369, no? Para 369.
Sorry?
Para 369.
No, my lord, 400 and
20.
which one? What do you want to show? Case law, both in the US and India, show this concept has traveled far from the mere right to be let alone, to recognition of a large number of privacy interests, which apart from privacy of one's home and protection from unreasonable searches, has been extended to protecting an individual's right in making vital personal choices, such as the right to abort, the right of same-sex couples, including the right to marry, procreation, contraception, general family relationships, etc., etc. So clearly, my lord, recognized by 9 judges that the right of choice includes the right to make a vital choice, as far as we are concerned, of a marriage of same-sex couple, and not only to be told that you may live together, but no more. That cannot be said, my lord, as is being argued.
97.
Then, my lord, a passage from Justice Call's verdict at 697. What is it?
97.
Can you keep giving us a PDF number?
697.
Can you give us PDF numbers actually?
It's easier for us then.
728.
728.
Keep giving us PDF.
PDA. All right. 640, para 647, my lord.
Yes.
Starts with saying, my lord, two aspects of the opinion of Justice Chandrachud, and which is common to the opinion of Justice Nariman, need specific mention, while the evolution of constitutional jurisprudence right to privacy referred to Suresh Kaushal, etc. Now, my lord, see the last 5-6 lines of that paragraph on that page. The sexual orientation, even within the four walls of the house, became an aspect of debate. I am in agreement with the views of Dr. Chandrachud, who in para so-and-so states that the right of privacy cannot be denied, even if there is a minuscule fraction of the population which is affected. Majoritarian concept does not apply to constitutional rights, and courts are often called upon to take what is categorized as a non-majoritarian view in the checks and balances of power envisaged in the Constitution. So this is a reiteration of my lord.
You might turn over the page.
My lord.
Where Justice Call has quoted from Mosley.
Yes.
Page 69, 698, para 130.
Yeah, Mosley, yes. So the David versus Goliath concept will not allow steamrolling. The observation made in Mosley in a broader concept may be usefully referred to. It is not simply a matter of personal privacy versus the public interest. The modern perception is that there is public interest in respecting personal privacy. It is thus a question of taking into account conflicting public interest considerations, evaluating them according to increasing well-recognized criteria. When the courts identify an infringement of a person's Article 8 rights, particularly in the context of freedom to conduct his sex life, personal relations as he wishes, it is the right to afford remedy and to vindicate that right. The only permitted exception is where there is countervailing public interest, which is to say circumstances strong enough to outweigh it. So what is important is, pausing here for a minute, right to afford a remedy and vindicate that right. I am wanting, Lord, vindication of my right. Then, Lord, this goes on. Now, Lord, after this, we go to Navtej.
So, Mr. Rohatgi, there are two corresponding rights and perhaps duties and obligations as well. On the one hand, the LGBTQ community has, or a same-sex couple is entitled to say, I have a right to make my own choices. We have our right to make our own choices, to live as we wish together. And therefore, that is a part of our dignity, our privacy.
Yes.
But equally, society can't say that, well, all right, we will recognize that right and we'll leave you alone.
Correct.
And we'll not recognize your
And no
relationship.
more. And which means, my Lord, the inequality must continue. We will get married. We will be the main people will look up to. But you are those, you just stay where you are, minus 377, and people will not look up to you.
So we will deprive you of the benefit
My Lord.
of conventional social institutions.
Yes, which we have as the majority, but you won't get it.
It's not enough really in terms of privacy to leave them alone.
Yes.
And to make their choices. But to assert a right equally to have the recognition of those social institutions.
So
which
you
give
are,
value
then you are at par. Then only you will be at par. Then the even, not even platform is the phrase used by Lord Chief Justice Chandrachud. How will it be even platform? Even platform means, my Lord.
It's not an equality. What Chief Justice is emphasizing is the corresponding duty on the state to.
Yes. It's not good enough to say, my Lord, leave you alone, minus 377, be happy. I'm putting it very.
Because, each of us, I said that in that part of the judgment where, in a sense, privacy is an individual concept, which allows you to get to the core of your being and to live your life as you want.
Your choice.
But equally, each of us are social individuals, social animals, so to speak. And therefore, for society to assert that, all right, we'll leave you alone, or the state will leave you alone.
But stay where you are.
We will not, exactly. We will deny you a recognition of those social relationships.
That's right.
Which go to the fulfillment of life. That, according to you, is impermissible.
Absolutely. Otherwise, there will be no one homogeneous unity in a nation, my Lord.
There's a positive obligation which is cast on the state.
My Lord, take reservations. Why were reservations introduced? There was inequality. For various reasons, rich, poor, caste, creed. State gave, my Lord, affirmative action to bring them up. That's why, my Lord, to bring them up so as to be at par. Because you were left behind for thousands of years. Bring them up with some reservations and then come on par. Still debate, my Lord, between reservations and To Navtej. Navtej Milad is at, what is this PDF page?
813.
PDF is 813 Milad, no? 814.
814.
Lord, I'm Justice Deepak Mishra, Chief Justice Milad, the first opinion.
Which page?
Kindly see paragraph 1 below.
855. 855 is where 3 running, 814 PDF.
Yes.
55.
So it has to be. It
are you referring to?
Below the first para.
Oh.
After the
Just
index.
1 second.
Paragraph. Not for nothing. Not for nothing. The great German thinker, John Goethe, had said, I am what I am, so take me as I am. Very prophetic. That's what I am saying now. And similarly, so and so. Then John Stuart Mill. But society has now fairly got the better of individuality. And the danger which threatens the human race is not the excess, but the Beloved, para 2 also. Second line. Denial of self-expression is inviting death. I mean, a bit much, but Milord, that's the import of that phrase. But Milord, turn to the next page. See para 4. And I submit, Milord, the same thing is happening even today, despite 377 having gone. The overarching ideals of individual autonomy and liberty, equality for all, sans discrimination of any kind, recognition of identity with dignity, and privacy of human being constitute the cardinal four corners of our monumental constitution, forming the concrete substratum of our fundamental rights. That has eluded certain sections of our society who are still living in the bondage of dogmatic social norms, prejudiced notions, rigid stereotypes, parochial mindset, and bigoted perception. Same thing continues. The only difference is, Milord, 377 is gone. So now, Milord, see Placidami, the first step on the long path. So this first step, Milord, business is by two judges. One here and one later. Yes. The Chief Justice wrote very long sentences. What you will find sometimes rather difficult, Milord, in several judgments. Sentences are very, very long.
the lighter side sharing that your late father used to write the reverse. He had the Lord Denning style of writing, very
Yes.
crisp sentences and
Small, yes.
small.
Short, yes. That's it. Very short.
Sentence per idea.
So that's the first path, my lord. See, my lord, the last three lines above para 5. We have to be ready to the perceptions, stereotypes, and prejudices deeply ingrained in the societal mindsets so as to usher inclusivity in all spheres and empower all citizens without any kind of alienation and discrimination. Non-acceptance by any societal norm or notion, punishment by law on some obsolete idea. That is the 377 business. Then, my lord, we go straight to
Very nice guy.
paras 96 and 97 and, my lord, page 880 of the compilation and page 98 of the report. PDF 910.
880.
My lord, PDF 910, para 96.
Page 880.
Yes, Lord. The rights that are guaranteed as fundamental rights in our constitution are dynamic and timeless rights of liberty.
Para?
96.
Para 96.
Yes. This is page 8. Yes.
The rights that are guaranteed as fundamental rights in our constitution are dynamic and timeless rights of liberty and equality. It will be against the principles of the constitution to give them a static interpretation without recognizing their transformative and evolving nature. Then para 97. Constitution fosters and strengthens the spirit of equality, envisions a society where every person enjoys equal rights, which enable him to grow, realize his or his potential. This guarantee of recognition of individuality runs to the entire length of the dynamic instrument. Constitution is conceived and designed in the manner which acknowledges change is inevitable, etc., etc. And then, my lord, one para. Kindly turn to, my lord, page 888 of the compilation. Para 127. This is again, my lord, minuscule part vis-a-vis the majority. That's para 127. The society as a whole, or even a minuscule part, may aspire and prefer different things. They are perfectly competent to have freedom to be different, like different things, so on and so forth, provided that their different tastes, liking remain within the legal framework. Neither will statute nor results in the abridgment of fundamental rights. 128. It is the concept of constitutional morality which strives and urges the organs to a state to maintain a heterogeneous fiber in society, not just in the limited sense, but in multifarious ways. It is the responsibility of all three organs to cover any propensity or proclivity of popular sentiment or majoritarianism. Any attempt to push or shove a homogeneous, uniform, consistent, and a standardized philosophy throughout the society will violate constitutional morality. So again, my lord, no steamrolling. The lordship may then turn, my lord, to
Page 134 at page 8.
144, my lord.
134 also.
134.
134. 134. In the garb of social morality, the members of the LGBT community must not be outlawed or given a step-brotherly treatment or malefactor by society. If this happens, or such treatment of LGBT is allowed to persist in the constitutional codes and the obligation to protect from it, would be failing the discharge of the duty. A failure to do so will reduce the citizen to a side. So, my lord, whether it is section 377, que the LGBT, or a fulfillment, my lord, of their rights to what we are requesting, if we are not provided that, my lord, then our citizenry, according to this judgment, will be reduced to a cipher.
The duty of the constitutional courts is to adjudge the validity.
Para 131 also, all right, my lord. One para earlier. 4 lines on that para. The court will adjudge the validity on well-established principles, etc. Para 144. Dignity. It's on dignity. Last 4 lines of para 144. The sense of dignity, and we say without inhibition, that is our constitutional duty to allow individual to behave and conduct himself or herself as she desires, to allow him to express himself with the consent of the other. That is the right to choose without fear. It has to be ingrained as a necessary prerequisite that consent is the real fulcrum, etc. Para 152 is a part, my lord, of that page on the top, sexual orientation. Again on choice. If your lordship sees, my lord, page 895, above para 153, on the top, placetum A. The third one has the proclivity which he maintains does not express in the inclination. The first one is homosexuality, second bisexuality, third heterosexuality. Third is regarding the natural. The first, by the same standard, is treated as unnatural. When the second exercises choice of homosexuality involves in such act, the same is also not accepted. In sum, the act is treated either in accord with nature or against the order of nature. 155. From the aforesaid has to be appreciated that homosexuality is something that is based on sense of identity. It is the reflection of a sense of emotion, expression of eagerness to establish intimacy. It is just as much ingrained, inherent, and innate, not merely an elitist concept. As heterosexual, sexual orientation as a concept fundamentally implies a pattern of sexual attraction. It is a natural phenomenon as other natural biology. When the science of sexuality is led to it, the individual has a tendency to feel sexually attracted towards the same sex, for the decision is one that is controlled by neurological and biological factors. So not acquired. It's not an acquired feeling or an acquired thing. That is why the natural instinct, which is innate and constitutes the core of identity, that apart on occasion due to sense of mutuality, two adults may agree to express themselves in a different sexual behavior, which may include both the genders. To this, one can attribute a bisexual orientation, which does not follow the rigidity, but allows room for flexibility.
167.
Paragraph 167.
This they're saying there is no right to marriage. It's wrong.
This is being relied upon, my lord, by the other side, completely out of context. But let's read this, 167. The above authorities capture the essence of right of privacy. There can be no doubt that an individual has the right to a union under Article 21. When we say union, we do not mean the union of marriage, though marriage is a union. So it can be things other than marriage. Yes. As a concept, union also means companionship in every sense of the word, be it physical, mental, sexual, emotional. The LGBT is seeking to realization's basic right to companionship, so long as such a companionship is concerned so free from the vice of deceit, force, does not resist the violation of attempt rights of others.
Just marriage. Just one.
Yeah.
What this means is this includes marriage, more than marriage also.
Yeah. Kindly then turn, my lord. Para 255 and 922 of the compilation. This is very, very important. Yeah.
So 167 is.
Lord, no judgment is read as a Euclid's theorem.
Which para are you referring?
Para 255 and 922 of the paper book.
953 of the PDF page number 9.
This is very, very important.
953 PDF. 922 running.
This is the bedrock of our rights, which are the same as that of the majority or the heterogeneous group. Kindly may not see this. The LGBT community possesses the same human, fundamental, and constitutional rights as other citizens, since these rights inhere in individuals as natural and human rights. We must remember that equality is the edifice in which the entire non-discrimination jurisprudence rests. Respect for individual choice, very sense of liberty, thus criminalizing carnal intercourse is irrational, defensible, manifestly arbitrary. True that principle of choice can never be absolute, etc. However, the organization of intimate relations, the matter of complete personal choice, especially between men, it is a vital personal right falling within the private protective sphere in the realm of individual choice. Such progressive proclivity is rooted in the constitutional structure and is an inextricable part. So it starts by saying, my lord, organization of intimate relations. And obviously it will include marriage, companionship, partnership, friendship, love, expressions. And the paragraph starts, my lord, this is the foundation. The LGBT community possesses the same human and other rights. If I have the same human and other rights, then there is no reason why I cannot, my lord, have the concept of marriage. And not enough to say that you are left alone, so be alone. See, my lord, 261. 2 pages down. That apart, any display of affection amongst the members of the LGBT towards their partners in public, so long as it does not amount to industry or has the potential to disturb order, cannot be bogged down by majority perception. It's all about majority perceptions, Milad. So now there is no criminalization, but the majority perception persists. That look at them, they are living together. What kind of status do they have? Lord, in the Indian society, every parent wants his child to be settled. One of the aspects of settlement is not only to choose your education and vocation, but is also marriage, family. You settle down. That's not ingrained in our society. Maybe other societies too. May not be in other societies, at least in our society. So we must have it, or we should have it. We request this court to grant it to us. And we'll add the conclusions here at 926, para 268. We'll see 268.3. Constitution is a living and organic document capable of expansion with changing needs. See 268.4. Primary object of a constitutional democracy is to transform the society progressively. So society must be transformed by law made by Parliament or by declaration of law made by this court under Article 141. See below 268.5. Constitutional morality embraces within its spheres several virtues, foremost of them being the espousal of a pluralistic and inclusive society. Concept of constitutional morality urges the organs, including judiciary, to preserve heterogeneous nature and to curb any attempt by the majority to usurp the rights and freedoms of a smaller or a minuscule section. 268.6. Right to live with dignity has been recognized as a human right on international front by a number of precedents of this court, and therefore the courts must strive to protect dignity of every. For without right to dignity, every other right will be rendered meaningless. Dignity is the inseparable facet of every individual that invites reciprocating respect from others, etc. The Constitution has laden the judiciary very important duty to protect and ensure the right to the nation, including the right to express and choose without any impediment, so as to enable an individual to realize his full fundamental right to live with dignity. Then, my lord, page para. Para. Then, my lord, one or two passages from Justice Nariman. My lord, your lordship will find para 314 is reference to Anuj Garg, that women employees case. Yes, I'll leave it at that. Your lordship may see only one para here. Lord, there is reference to Shafin Jahan and Shakti Vahini. That is the right to choose a partner, but I will show it from another opinion. Those are referred here. Shafin Jahan and Shakti Vahini, my lord, are judgments of this court that a person has a right to choose a partner for marriage. But I want to show it from another opinion. Your Lordship may turn, my lord, to the opinion of Justice Chandrachud commencing at page
352.
sorry, one para 352, and then, my lord, his lordship's opinion. 352 is, my lord, an answer to the fact that you wait for parliament. Para 352. Kindly turn to para 352. This is very important, my lord, to repel that argument. Another argument raised on behalf of the interveners is that change in society, if any, can be reflected by amending laws by the elected representatives. Exactly what is argued today. Leave it to parliament. Very, very important issues is what they say. Thus, it will be open to parliament to carve out an exception. But this court should not indulge in taking upon itself the guardianship of changing societal mores. Such an argument must be emphatically rejected. The very purpose of fundamental rights chapter is to withdraw the subject of liberty of the individual and place such subject beyond the reach of majoritarian government, so that constitutional morality can be applied by the court to give effect to the rights, among others, of discrete and insular minorities. This is taken, my lord, from a US judgment. So idea is to take it away from the right of majority governments, which means parliament, and leave it, my lord, to the courts. One such minority has knocked on the doors of this court, and this court is the custodian of fundamental rights of citizens. These fundamental rights do not depend on the outcome of elections, and it is not left to majoritarian governments to prescribe what shall be the orthodox in the matter concerning social morality. Fundamental rights chapters like the North Star of the universe, constitutional morality always trumps any imposition of a view of social morality by shifting a different majority. A complete answer. This is the province of this court. It is not the province of parliament. Parliament can certainly do it. But this argument can't be raised, leave it to parliament. Because your lordships are the protectors of fundamental rights under part 3. And therefore, if my right is violated or not effected or not given me lord full play or panoply of my rights, I must come to the court. And the court will grant me. And repel the argument that wait for parliament to act as and when it chooses to act. Because no mandamus lies to parliament. My lord, then 369 is the penultimate paragraph of Justice Nariman. See 367 actually. 367 is to debunk the theory of Kaushal. See, my lord, 367 and 369. 367 debunks Kaushal. That only 200 people are being prosecuted, etc. The lordship says neither here nor there. Now 369. We may conclude by stating that persons who are homosexual have a fundamental right to live with dignity, which in the larger frame of preamble will assure the cardinal constitutional values of fraternity that has been discussed in Nandini Sundar, Subramanian Swami, etc. Now, my lord, a few passages from the opinion of his lordship, my lord.
370, the directions of the court.
My lord, just note that in 370, there were directions that they should give full publicity or all media to this judgment. Only to say, my lord, that today's paper says nothing has been done. 5 years have gone by.
GB is not covered.
Nothing.
The allocation of business rules.
They say allocation of business rules do not cover, my lord, LGBT. What is allocation of business rules to do when you have to, my lord, implement an order of this court? This is how, my lord, they give not even lip service. This disdain. This disdain of the court's direction. Now, my lord, kindly turn, my lord, to the opinion of Justice Chandrachud. Your Lordship may, my lord, straight away, there are some passages. Kindly turn, my lord, to 406, para 406. Chapter starts with equal love. 407, Article 14 is Fundamental Charter of Equality. Then see, my lord, 418. Difficult to locate any intelligible differentia between indeterminate terms as natural, unnatural. Even more problematic to say classification. Individuals who supposedly engage natural intercourse and those who engage in carnal, against the order of nature. But that was not for 377.
Natural way of raising children and an
Yeah, that's all right. My lord, then let's go straight to the major ones here. We can't go to so many. Your lordship will find, my lord, 431. Formalistic interpretation. In fact, my lord, at 430, page 1000 of the report, towards the foot, my lord, is the interpretation in Nargesh Mirza. That is, my lord, on the words, on the ground only of sex, under Article 15. That, my lord, is explained in 431 and 432. And in 432, your lordships will note the divergent note in Anuj Garg. Come straight to this.
Yes.
My lord, paragraph 438. Just above para 438. The view in Nargesh, my lord. Anuj Garg was the test for Article 15, not only on the ground of sex. Anuj Garg is approved, Nargesh is disapproved. That, my lord, is just one line above para 438. That is on Article 15 now. 439, the court records Nargesh is incorrect. And 440, a provision challenged as being ultra vires the provision of discrimination on the ground only of sex is to be assessed not by the object of the state enacting, but by the effect that the provision has on the affected individuals and their fundamental rights. Any ground of discrimination, direct or indirect, founded on a particular understanding, would not be distinguishable from the discrimination which is prohibited by Article 15 on the ground of sex alone. See the doctrine of effect. What is the impact? What is the impact on us in not being able to marry and say, all right, you live like this, like a live-in couple, as opposed to, my lord, the heterosexual group. Because live-in couples also have rights now, my lord, under the DV Act. Even that is not given to us. My lord, para 462.
461, Mr.
Or 461. History has been witness to a systematic stigmatization and exclusion of those who do not conform to societal standards or what is expected of them. 377 rests on deep-rooted gender stereotypes. In the quest to assert their liberty, people criminalized by operational provision challenge not only existence but also a gamut of beliefs they strongly rooted majority understand of what is normal. In this quest, the attack on the liberty is a challenge to a long history of social history. Persecution of people based on it. They have been subjugated to a culture of silence, leading their lives in closet. There must come a time when the constitutional guarantee of equality and inclusion will end the decade of discrimination practice based on majoritarian impulse. That time is now. So it was now then, my lord, for 5 years back for 377. I think should be time now for what, my lord, we are expecting as a natural consequence of what has happened in the 5 years. Then, my lord, confronting the closet. The right to privacy is intrinsic to liberty, central to human dignity, and the core of autonomy. These values are integral to the right of life in 21. Meaningful life is a life of freedom and self-respect, nurtured in the ability to decide the course of it. In the 9-judge bench, this court conceived the right to privacy as natural, inalienable. The judgment delivered on behalf of 4 judges holds. Privacy is a concomitant of the right of the individual to exercise control of his personality. Finds an origin in the notion there is certain rights natural and inherent. Natural rights are inalienable because they are inseparable to human personality. Human element in life is impossible to conceive without existence of natural life, etc., etc. Then, Milady, if your lordship turns to 464, Puttu Swami rejected the test of popular acceptance, which was found in Kaushal. Then, para 144, Milady. I have read that. Paul concurrence. I have also read, which is on the next page in the middle, where para 647 is read. Formula 465. See third line. This is important. While facially, section 377 only criminalizes certain acts, not relationships. The argument is relationship is not criminalized, you carry on. What is criminalized is not removed. But that is not good enough. It alters the prism through which a member of the LGBT is viewed. Conduct and identity are conflated. The impact of criminalization, non-conforming sexual relation is that individuals who fall outside the spectrum of the heteronormative sexual identity perceived as criminals. Now, I am not perceived as a criminal, but I am still perceived as a person who is not up to no good or who is not as good, unworthy of standing shoulder to shoulder in the public arena with the heterogeneous group. 466 also. 466 Milad. World over, sexual minorities have struggled to find acceptance in the heteronormative structure imposed by society. Then Milad, 467. To deny the member of the LGBT community the full expression of the right to sexual orientation, deprive them of entitlement to full citizenship. This is very, very important. I'll read this again. To deny the members of the LGBT community the full expression of the right to sexual orientation is to deprive them of their entitlement to full citizenship under the Constitution. Pause here for a minute, Milord. When you deny me the right of marriage, you deny me, Milord, citizenship. If you deny me citizenship, you are saying you are no good. You are not equal to a citizen under the preamble. So you stay where you are, Mr. So-and-so. No criminalization, no, you won't go to jail, but stay, my lord, in the closet or in the bedroom and do not come out, my lord, hand in hand or ask for this marriage business. That is 467. My lord, 468 also. This is on privacy to incorporate a right to sexual privacy. Inalienable right to privacy must be granted the sanctity of a natural right to protect in the Constitution as a fundamental right and the soulmate of dignity. So privacy, dignity go in hand in hand. Dignity is a part of, my lord, life lived to its fullest under Article 21. Then, my lord, 470, just, my lord, see 4 lines above 472. It must, placetum A on that page.
469, 469, P and D.
Yes.
Yeah, I'll read 460. Citizens of a democracy cannot be compelled to have their lives pushed into obscurity by an oppressive colonial legislation in order to ensure to sexual gender minorities the fulfillment of fundamental right. Imperative to confront the closet is a consequence confront compulsory heterosexuality. Confronting the closet will entail reclaiming markets of all desires identity in acts which is challenged. 229. It will also entail ensuring the individual belong to sexual minority have the freedom to participate in public life, breaking the invisible barrier that heterosexuality imposes. I am grateful, Miran. This para is important. So this is again steamrolling by the heterosexual over below this minority. Milord, may I continue for half an hour tomorrow, Milord? And I will. I am grateful, very grateful. Start from